Hello, good morning. Dear ladies and gentlemen, dear colleagues, dear guests, so it's a pleasure for me to welcome you at the second international conference of the WISE project, which is considered to help us to reimagine the European Union and to discuss the contemporary values or value of the European Union. And to begin with, I would like to first of all thank to the hosts, to the Charles University in Prague for welcoming us here at the University in Prague and for hosting the conference. We really value, it's of great value to have a very devoted partner who participates very actively in the project and who have kept the promise made maybe as far as I remember 4 years ago to have an international conference together. So thank you very much. To start with, I would like to just talk a little bit about the project itself, because we have new people coming and maybe people hearing about the WISE project for the first time. So this is the initiative which is funded by the European Commission, by the program Europe for Citizens. And all the events that are set for this project are devoted for commemoration of the end of the Second World War. So talking about this event, we consider it to be one of the most important events in the history, unfortunately very painful. But looking at this event from today's perspective, we think that it's very important to learn the lessons. First of all, to identify the mistakes that were made by the nations participating in the war, and to analyze what was the aftermath of the war. As we say, we have very, very different experiences in different countries. If we talk about the war in Western Europe, so we consider that the war was over in 1945. Unfortunately, we cannot talk about this date in the Eastern Europe, as for instance in Lithuania, we think that the war was actually over when we got independent from the Soviet Union, and it was only in 1990. So it makes difference. It makes difference in terms of experience. It makes difference in terms of how we understand the common values and how different generations of people understand their identities, and how can we work together having different backgrounds, although we are all Europeans. So, and the project consists of a series of different events. So the first event was the conference hosted by Mykolas Romeris University in Vilnius in the end of 2015. It was basically we talked about the international crimes and lessons learned from various infringements of human rights during the time of the Second World War, and then the aftermath, and then we had a school children competition which was taking place in Auschwitz-Birkenau Museum, and it was on the perception of the Second World War by youngsters. Then we had the brilliant event, the summer school on international protection of human rights, where all the partners took a very, very active role, and we had an intensive course designed for the students. And finally, we are having the last event, which is the conference in Prague, and this conference is devoted to, as I have already mentioned, to discussing what values are common to us. Do we understand the values that we consider to be the core of the European Union when it was founded, and what is the contemporary value of European Union itself? We are coming back to these questions as we see different processes, ongoing processes happening in different member states, and for instance, a very, I believe, a painful experience for the European Union, which was called Brexit. So And we will try to discuss what kind of reasons led to Brexit as one of the events, and we will try to come up with a certain policy guidelines to the European Union in terms of common understanding of values of European Union. So this is very, very short introduction of what we're going to do, and I have a pleasure to invite the Dean of the Faculty of Law of Charles University in Prague, Professor Jan Kuklik, to give a welcoming speech. So the floor is yours.
So thank you. It's my pleasure to say a few words at the beginning of this conference. I must say that I personally was very much interested in the theme of the project, so I, together with David Kohout, we followed the beginning of the project, and we were convinced that this is the project which is very important, and that the discussions which are related to the themes of the conferences, or both conferences and other activities, are extremely important, especially at the time when you mentioned also some kind of a crisis within the discussions on European Union and its future. So I think that it's also necessary to look back to the historical foundations to seek the roots for the European integration, and to rethink also its role in today's world and its role in the future of Europe. So I think that conferences like this one are extremely important in this situation. And I'm very glad that you were all able to come, and that we are hosting this conference. And I hope you will like also Prague and the venue of the law faculty. So this is our special conference room, but you are also welcome to see something more from this building and from this university, and I hope that you will free here like at home. So this is our intention. I think that I will speak a little bit on the theme during my lecture, so I think I can really, I hope I can shorten the introductory speech, but I think that it was my role as a host, and again, welcome here at the law faculty in the Czech Republic.
Thank you very much for very warm, welcoming words, and I would like to invite you to start our conference with the first session. Just several remarks concerning the way we are going to get the presentations. So we will be, as you have already seen, we will be working in plenary, and as we are having live broadcasting, so I would like to ask to use microphones, because without microphones we will not have a proper sound for live stream. And as you wish, you may use, as we have all the presenters sitting here at this part of the table, so you may sit there and you may use the microphones that are at the table, or you may come here as you wish, as you feel more comfortable. Now, when it comes to the questions, so as we have a separate part for the discussion, so I would like to ask just to make the list of the questions and then to raise them during the discussion, because we have the time reserved for that, no? And then, of course, when we finish with the time for the discussions, we can continue discussing the things during the coffee breaks that will be organized just here on your left. So we are starting from the plenary in search of European identity. The European Union has been searching for European identity for numerous years, and it seems that, at least on paper, from Lisbon Treaty, we have European Union as such. We do not have like a double identity, but then the question is what is behind that. So we are going now to discuss several issues of identity, starting from the very general one. So what was the way the European Union or the Europe could choose before it decided to be European Union? Because there were a lot of discussions in the beginning after the Second World War what kind of form Europe, the cooperation in Europe may take. So I would like to invite again the Dean of the Faculty of Law, Professor Jan Kuklik, to start the conference with the presentation with the question, a very good question: was there an alternative to the Sovietization of Central Europe during 1945 and 1949? I believe that this will help us to raise further question and to discuss then afterwards what kind of tools we have to express this identity. So the floor is yours.
Thank you very much. So I think that it might be the first crisis of my identity to start now a lecture after welcoming address, but I try to switch from the role of the dean to the role of professor of legal history. I think that the first important remark is why I choose this theme for the conference with the title Reimagining the EU, the contemporary values of the EU, with the theme which is of course related mainly to history. But I think that partly I answered this during this opening remark, because I believe that in today's discussion, when we try to search for European identity, it's really necessary also to analyze some historical factors which led to European integration. And then I think that if you see the discussion on European identity from the points of view of various nations and states in Europe, you will quickly realize that the historical experience of different regions in fact influence the discussions on European identity today, because without understanding the different historical development, it will be very difficult to search for the common present and future. And I think that discussions even on such issues like migration crisis, I think it's very important to notice that the historical arguments are really very quickly coming into the debate, and to ignore them, I think this is simply a mistake. On the other hand, I think that it's really necessary to see the problem from different perspectives, and I am not of the view that the solution should be done only through the national interests of individual states or group of states, because otherwise the union is not working. So this is, of course, a question for maybe another conference and things like that, because of course this discussion is going on, and we cannot solve it here. But I think that we can or I can now try to give you maybe some remarks on what I am having in mind speaking about Central Europe. I think that I will not concentrate now on maybe even the definition on Central Europe, which might be also the question for lengthy discussion. And of course, I can say that I will use mainly arguments, or I can see it mainly from, of course, Czech or Czechoslovak point of view, but also taking into account Polish, Austrian, Hungarian, and other aspects. But of course, there was the key question of the position of Germany during and after Second World War, which is very important for for Central Europe, or you can see it as a problem of smaller states between Germany and Russia, or between Germany and Soviet Union, which is, of course, the key question for Central Europe for centuries, but especially during the 20th century. Another opening remark, or first remark, is that when you speak about European integration, from historical point of view, usually you concentrate on those states who formed the first form of integration, mainly on Western Europe. So the first story of European integration is in fact told from the point of view of Western Europe. But I think that to understand the position of other states, I think it's sometimes, I think, for those states also necessary to think about the position of those states who were on the, let's say, wrong side of division of Europe, which occurred already by the end of Second World War, and especially in this period I just mentioned in my presentation, came into reality. So if we then can see Europe after Second World War as a Europe which was divided into those parts which was, let's say, lucky enough to have the possibility to integrate more closely, and then when you have the Europe which was on the wrong side of the Iron Curtain, then of course the debate could be even more interesting. Of course, this is of course more complex problem that to see it only from this point of view. But I would like to mention it for the discussion for searching of European identity, because again, without taking this experience into account, it will be very difficult to understand Europe even today. I think that there is another problem to this sort of discussion, and it is that, of course, during Second World War, there originated several initiatives which you can regard as preparatory steps for European integration, or discussions on possibilities of European integration, which were, from one point of view, also part of discussions on New World Order after the Second World War, which was connected, of course, on wartime policies of allies, and which led, for example, to the establishment of United Nations organization, and to initiatives which were, for example, connected with cultural, scientific cooperation, but especially economic. Because, of course, the war was not only war against Germany, Japan, and allies, but it was also the question for, post-war development. So you can see discussions on post-war development throughout the whole period of Second World War, and some of these discussions, of course, influence also later the discussions on European integration in the Western part. When the question was if there was any alternative to what happened, because we know what happened. Of course, this is not the lecture about if in history. This is maybe the lecture on what was really on the table, what was really discussed, and what then led to the division of Europe and to the development which I described as a, let's say, the dual experience from the post-war Europe, from Western and, let's say, Central Europe and Eastern Europe points of view. I think that the first possibility was, of course, to find the solution of for the states which were between the interests of great powers, between the Germany and between the Soviet Union. And I think that already in the interwar period, you can see that some initiatives were very closely related with the federative structures, for the proposals of federative structures. So, of course, when you then see the discussions on integration of Europe, and one stream was really heading for discussions on United States of Europe or federative Europe. So I think that these discussions, of course, are closely related to the problem. I think that this was, in fact, one of the alternatives which was on the table, which was also negotiated. But I think that when we see the result, we can have an answer to one reason why it happened, how it happened after the Second World War. I think that I would like to mention especially the idea of Central European Federation, which was in fact also closely related to the first project, which was proposed by Aristide Briand in 1930, and this was the idea of regional federations, which then together can form some kind of European federation under the auspices of League of Nations. We know that the League of Nations collapsed already before the Second World War, but I think that then the discussions about the United Nations organization as some kind of a replacement of League of Nations could be also interrelated to the discussions about the regional federations during the Second World War. And we know that one successful result of the discussions on regional federation was in fact the negotiations between Belgium, Netherlands and Luxembourg, which led to the first form of their collaboration, which later was transformed into the first step leading to the European communities. But when you look what happened with the idea as a whole, the discussions between Czechoslovakia and Poland, which led even at the beginning of 1942 for signing a protocol and an agreement on post-war cooperation and confederation, how they called it. They tried to solve even the discussion on federation and confederation projects, but then it failed because then the Soviets intervened already in 1942, but in 1943 it was quite visible that the idea of Central European Federation is not in the Soviet interest, and although the whole idea was backed mainly by Great Britain during the Second World War, the project collapsed. The similar project was proposed for Yugoslavia, for Greece, maybe for Bulgaria in the east, and again, I think you can see on the negotiations on the federation project that it was quite interesting idea, that it really fit into this alternative to use the group of regional federations to resist the pressure from both regional powers. But again, I think that mainly the Soviet policies during the war prevented even to negotiate on the question. So the result of this was that Great Britain in fact rethink the whole model, and I think that there is very interesting proposal by Anthony Eden in 1942-43 period, when he tried to find a solution of a model of great powers of Big Three and some model of regional cooperation between the states, even of the region of Central Europe. I think that I don't know if you heard about this initiative, but I think it's very interesting when you then see what happened after the war. And I think that he proposed to establish 5 regional councils and also European Council to be composed of representatives of United States, Great Britain and Soviet Union, to be something like the Council of big powers, of great powers, and then to have the proposal for regional cooperation. I think that also nothing new that Winston Churchill several times during the war, but also after the war, spoke about United States of Europe. But I think that when you mention Brexit, I think that this is quite interesting story of the British policies and their views on Europe, because not only during the war, but until 1949, until the establishment also of Council of Europe, you can see that the British policy was to foster the European cooperation without Britain, or to see the Britain in a very different position towards Europe. So I think that this first alternative, which in fact also then influenced the thinking in Western Europe on European integration, in fact collapsed and left the Central European countries to rethink this model. And of course, what they did, they of course come with their proposals to re-establish national states. And the reaction of states like Great Britain or United States, which can really guarantee some kind of independent development within the region. So I think that it's also very clear that the whole development after 1945 in the region is, of course, the balance of powers. Of course, I'm not of the view that the individual smaller states are 100% dependent on the decisions taken by great powers. So, for example, I'm not of the view that the Yalta Conference decided everything in Europe, or almost everything in Europe. This is just not true when you see the proceedings, and when you see that there were some agreements reached there, but this is not the story that everything was decided, and we cannot do anything with our history. I think that this is quite a dangerous view, in fact. But I think that for the individual states in the regions, what they did, that they of course think that the best way will be to re-establish national states, and maybe to think also about some territorial gains. So the notion of cooperation and seeking some kind of alternative to the post-war development, in fact, then changed into quite a different story, because this was, I think, part of the problem, that the notion of national state, of course, is part of the problem when you discuss on the European identity. Of course, if you can have the double identity or things like that, that's for sure connected with national states. And the Second World War showed, I think, that this notion of national state was very strong, especially when it was connected with the situation which was during the war. It was the war against aggressor. Those states were occupied by Germany. This is also necessary to take into account. And I think that it's also connected with such questions like searching for either re-establishment of the state within the pre-war borders, or in Polish case, and this is very important, to seek new borders, new status for Poland, especially because it was quite clear during the war that the Soviet Union will not give up its gains during the war, and that it's necessary to compensate Poland in the West. Then the whole question suddenly is connected with some other problems which originated during the war and realized in this period, but in fact, as their outcome, they helped the Sovietization of the region, and it was the question of this concept of national state without national minorities. So not only to change territories, but to solve also the complex national situation of the state. So, of course, it was mainly dealt with the question of German minorities within not only Central Europe, but there were German minorities even in the Baltic states. There were German minorities in the territory of Ukraine or the Soviet Union. There were German minorities or German-speaking people in northern Italy and things like that. So the situation was more complex, but for the region, this was really very much connected with this question of re-establishment of, let's say, independence of such states and their composition after the war. I think that at the beginning, what you can see that all great powers see this process in their advantage, as their advantage. For Britain, especially, they came with this solution. They were the advocates of this solution during the war until the Potsdam Conference, with their view that helping states to get rid, for example, of German minorities can strengthen their societies, and that as a strong national states, they can resist pressure from Germany and Soviet Union. And then maybe they can return back, for example, to some such ideas as regional federation or a kind of European integration. But from the point of view of the Soviet Union, they helped this process just to reestablish these states in their sphere of influence. Especially when you have to see it also within the whole scope of discussions on the so-called German question. Of course, there is another problem, and it is when you see the history sometimes from the point of view of the individual states, you can get sometimes maybe wrong results from the whole European perspective. And this is exactly the case, because for the great powers, the biggest problem was the German question. So the whole negotiations on the post-war development were in fact the negotiations on the German question, and these were the questions related to it. So in fact, for the Soviet Union, it was quite easy to then misuse also this concept of re-establishment of national states, especially when, of course, for the Soviet policy, it was the policy of territorial gains, of the classical sphere of influences. And of course, then all hints of kind of European cooperation, which then realized in Western Europe, were against the Soviet interests. And then, of course, there were many internal factors. I think that we don't have enough time here now to analyze the process in individual states also from the internal policies point of view. But I think that when we can sum up maybe at least some of the most important questions was that the searching for some kind of alternatives was very much connected with the policies you can formulate and some kind of real possibilities. And when you see the situation really between 1945 to 1947-48 period, then of course the question is what was offered by the West to Central and Eastern Europe to avoid the Sovietization of the societies. On the other hand, what is the internal factor? There was very strong movements, especially within societies like the Czech one, where you can see the abandoning of pro-Western orientation and, of course, connection with the question of rebuilding of society on new foundations, influence of older socialist ideas connected with the influence of Soviet Union as a social experiment which could be implemented also in Central Europe, together with, of course, the military victory at war. So you have too many elements to the discussion about the post-war development, but I can add one point which is for me very interesting, or maybe 2 points. One point related to the Iron Curtain discussion. I think that Iron Curtain is usually connected with the Churchill speech at Fulton in March 1946. But when I analyzed the documents of the British Foreign Office, I found very interesting remarks about the Iron Curtain in Europe already in May 1945. So they used this expression on the post-war development already by the end of Second World War. And what is this interesting point? They came to this conclusion after the discussions about the possibility to liberate Prague by American army, which of course is a typical story for the one nation only, but only from Versailles, because when you see the discussions about this possibility, there was some kind of a symbolic value of things like resisting the Soviet demands on the spheres of influence. But I think that here you can see that sometimes the case of one country was, of course, replaced by negotiations in some other parts of Europe. In this case, it is quite visible that it was the division of Austria, according to negotiated spheres, and of course the spheres of occupation in Germany. And then, of course, it was not the value for the American army to do this step, which then led the British, which supported it, and especially Churchill personally, from the symbolic point of view. And when it failed, they came to the conclusion that this is the first Iron Curtain which occurred in Europe. I think this is quite interesting view. But on the other hand, it was not the end. Then there were some negotiations on the balance of powers for Central Europe. But you can see two strategies. One was the Czechoslovak, one was the Polish, because both states have their exile governments. Both states adopted quite different policies against or towards the Soviet Union. And I think that what is interesting, in both cases, they failed, in fact. So I think that then for the alternative, this is of course very difficult to say if there was an alternative, because the Czechoslovak position was to maintain friendly relations, even to conclude an agreement on alliance, and to secure the independence through international agreement with Soviet Union. But of course, what happened? They didn't follow the negotiated terms. Then, of course, the Polish government, of course, the position of Polish exile government was more difficult, but they of course adopted the stand that there are certain Polish interests they cannot, they have to formulate it. They cannot abandon them. But then the result was that the Soviets installed their pro-Soviet committee, later recognized as a provisional government of Poland, and the result was that the Western powers, in fact, also yielded during the series of international negotiations on that. So then I think that for Central Europe, the lesson learned from those negotiations were that what could be the strategy for the states? I think that then, in fact, the only strategy which paid off was the Austrian one, but for very different reasons. But of course, the Austria was not even the Allied states at the beginning. But this is, of course, I think maybe one story you can see from the end of the Second World War and from the searching of some alternatives to what happened. I think that it was not so that everybody welcomed the development leading to Sovietization of Central Europe. And then I think that this memory and those problems related to it should be taken into account. The second point, and it will be the closing remark, I think, especially because of the time, but we can discuss, of course, more and more, was that the strategy of the Western powers towards the region was also to help the economic recovery, to establish some kinds of economic relations, which then could be strengthened by some political ones, because they of course realized that the military and other possibilities are very limited. So the role of economic recovery, especially paid by the American money connected with the UNRWA program, is of course directly connected with the key question: what to do after UNRWA program, which was quite successful project connected with the United Nations Organization strategy to see the cooperation worldwide based on the Allied coalition during the war. But when the UNRWA ended, then of course the United States came with the Marshall Plan. With the Marshall Plan, which was opened also for the Central and Eastern European countries. Soviet Union first said that there is no intention of the Soviet Union to take part in the program, but left Czechoslovakia and Poland to negotiate on the acceptance of Marshall Plan. And I think that especially the story of the Czechoslovak acceptance of the plan first, and then to recall the acceptance, is a very good example how the diplomacy and the Soviet policy was working in the region. And I think that this was in fact the last chance for the Central Europe to make certain balance, and after that it was only maybe step-by-step strategy for the Soviet Union to gain practically everything for Central Europe. But I would like to mention another project, and it was European Coal Organization. I don't know if you heard about this organization. It was very interesting project by the proposed by the British already in 1944. And when you then see the success of European coal and steel community, I think that this was quite interesting proposal, which materialized in 1945, and it was a proposal for European states to cooperate in distribution of coal as the key commodity for the post-war reconstruction. And also, not only Western European states took part, but also Poland and Czechoslovakia were invited, and it looked like the possibility again to offer something for the Central Europe and to maintain some kind of balance. I think that again the story of this organization ended on the discussion also on the institutional structure, and I think it's very interesting thing that theoretically the proposals connected with this organization were very close to what was discussed at the beginning of 50s, but it failed because of the political reasons. And I think that the story of this organization alone could be something like a test case for the post-war development, and again for the memories for this region, which they tried to do something, but of course it didn't materialize, or what then happened is of course connected with the division of Europe into two main blocks. But I think that of course I was able to mention only certain aspects. I think that we can then maybe discuss something more, and I'm not sure if I fit into the proposed time limit, but so please forgive me if I did it longer. Thank you.
Thank you very much for very interesting insights, and in particular youngsters, so people from young generation, in most of the cases they focus on what happened in their time, so it's very, very good to hear the insights about what was going on there before we got to the European Union, and it really helps to understand how we got these two blocks of the states, that the states, one of which got into integration quicker, and the other one was a bit the integration of which was set aside. So, well, thank you very much. I believe that there will be questions then afterwards during the discussions, and now I would like to ask to move forward, and Professor Michal Urbanczyk is already taking the floor, and the professor is coming from Adam Mickiewicz University in Poznan, and the presentation will be on the philosophical foundations of human rights in context of European integration. So we heard about what led us to, what kind of processes political processes led to the situation we had before the creation of European Union, and now we will talk about what are the foundations, philosophical, basically, the values that were common at that time, and I would like to pass the micro.
Thank you very much. First of all, I would like to thank you, the whole WISE team, that I can be part of of this conference. It is honor and great pleasure for me. I would like to thank the Charles University for hosting, and I would like to thank Professor Kuklik for the very interesting speech about the history of the Central Europe. And this is quite interesting that when we are talking about the identity in this conference, the first plenary session, the whole lecturers are from Eastern Europe, not from the West, and maybe this is the question, that maybe on the Western Europe the problem of the identity isn't so big as it is in the Eastern Europe. I would like to talk about rethinking the philosophical foundation of human rights in the context, of course, of European integration. And at the beginning, of course, the human rights are specific but also a typical concept of the last 60 years. And it is worth mentioning that this concept has legal, moral and political aspects. We have the Universal Declaration of Human Rights, which was adopted by the United Nations General Assembly in 1948, and it became a model for the constitution for many countries. Following this declaration, human rights slowly entered international law through, among others, the European Convention of Human Rights, the American Convention, and of course international covenants from the 1966. In Europe, human rights are also declared in the Charter of Fundamental Rights of the European Union, which respects certain political, social and economic rights for European Union citizens. It was drafted by the European Convention and proclaimed on December 2000 by the European Parliament, the Council of Ministers and the European Commission. It is worth mentioning, however, that its legal status was uncertain and it didn't have full legal effect until the entry into force of the Treaty of Lisbon on December 2008. Of course, the idea of rights held by all in virtue in their humanity can be found long before the late 40s. For example, in the American Declaration of Independence or in the French Declaration of the Rights of Man and the Citizen. As a natural rights in the meaning of rights held by people as a matter of natural law, this idea could be found in the exceptional and predominant 17th and 18th works of John Locke, Hugo Grotius, Samuel Pufendorf, and of course, last but not least, Immanuel Kant. When we are talking about the nature of human rights, we have to take a move to the notion of natural rights. And these rights that all human beings possess simply in virtue of their humanity and which can be identified simply by the use of ordinary moral reasoning, a natural reason, as opposed to the sort of conventional reasons created with particular social or institutional context. And in some generalization, of course, it is commonly recognized conception, and this conception we can describe as that human rights are moral rights that all human beings possess at all time and in all places, simply in virtue of being human, and that the corresponding duty bearers are all able people in appropriate circumstances. And of course, that the foundation of human rights is human dignity. And this is the core of the Western world, especially European world identity, and the core of European thinking about the identity. And of course, we can show many examples in the international and European law. The Universal Declaration of Human Rights, where we have the dignity and the worth of the human person and its equal rights. We have in the preamble, we have apart this Article 1, when we can read that all human beings are born free and equal in dignity and rights. We have the International Covenant on Civil and Political Rights, which recognize of the inherent dignity and of the equal and inalienable rights of all members. We have, of course, and we cannot forget about it, the Protocol 13 of the Convention for the Protection of Human Rights and Fundamental Freedom concerning the abolition of the death penalty. We have the Charter of Fundamental Rights of the European Union, where in the preamble we can read about that the Union is founded on the indivisible universal values of human dignity, freedom, equality and solidarity. And the end of the 20th century, especially 1989, and the collapse and breakdown of the communism, agreed that the human rights and the idea of liberal democracy, another part of the Euro-Atlantic identity, is winning the worldwide game. That's why Francis Fukuyama wrote his famous essay, The End of History, which was published in the National Interest, where Fukuyama argues that the advent of Western liberal democracy may signal the end point of humanity's socio-cultural evolution and the final form of human government. And the Fukuyama wrote, "What we may be witnessing is not just the end of the Cold War or the passing of a particular period of post-war history, but the end of history as such, that is, the end point of mankind's ideological evolution and the universalization of Western liberal democracy as the final form of human government." Most important process at this point of view was European integration and the year 2004, post-Cold War enlargement of the European Union. The official EU media, for example, the speeches of the European Commission, frequently referred to the enlargement to the Central and Eastern Europe region as an historical opportunity and morally imperative. And this one reflected the desire of the EU to admit these countries as members, even though they were less developed than the Western European countries. But we had to remember that the history didn't stop. And 3 years earlier, the history began to move. The 9/11 started the new era in history of the world and in the history of Europe too, because of the terrorist attacks since 9/11. We have the 2004 Madrid train bombings in Spain that were inspired by Al-Qaeda. We have the July 2005 London bombings that were perpetrated by 4 terrorists, one of whom appeared in an edited video with a known Al-Qaeda operative. And in the 21st century came with another cornerstones of the history. We have the financial crisis, 2007-2009, which is considered by many economists to have been the worst financial crisis since the Great Depression. We have the fail of the treaty establishing the Constitution of Europe, commonly referred as the European Constitution, which was unratified. And after this, we had the ignoring the will of the citizens of Europe countries, for example, the French and the Dutch referendum, and EU leaders signed the Lisbon Treaty. We have the refugee crisis. In Eastern Europe, we have the annexation of Crimea by the Russian Federation and Russian invasion of Ukraine. We have the problems with the politics of the multicultural society and the rise of xenophobia and aggressive chauvinism. This whole is new scenario for the human rights and for the human dignity. And for us, who European integration is a positive process, this whole new scenario is a great challenge. And I think that we, the Europeans, have to one more time answer to the question, who we are and where we are going to. What is the direction of the European integration? And of course, what is the future of the EU and the European values, like the human rights and the human dignity. And I think that the main issue in the EU today is whether we know where are we going as a community. And considering the many crises facing Europe, not only that I mentioned before, but the Greece, the Eurozone, the Polish constitution crisis, of course, it seems that we are not sure who we are as a community of value. And Dawid Bunikowski from the University of Cardiff said that we have to put on the table two arguments, both connected with human rights. One is about common European values rooted in history, which should illuminate the future. And the other concerns democracy in the EU and the will of European people to decide on the future of the European Union. I agree with Bunikowski that without strict axiological foundation, the sense of existence of the EU would be based only on economic and commercial reasons. Every organization should be based on concrete values, and this is a major problem for the EU. Our European legal culture is made up for not only the continental law tradition and common law origins, but also the axiological foundation, which come from the Greek philosophy, Roman law, and the Christianity, in which, and I think this is very important, in which the human rights and the idea of human dignity are deeply rooted. No society can exist without its history, tradition, and origins. Where would we, Europe, be without our history, where the human rights and the idea of human dignity and the fight for the human dignity played a major role? And we must remember that values cannot be an empty concept or nor a hollow right. And this choice of values should be consistent with the feelings of EU citizens. Maybe then the EU would be more internally effective and externally influential. The rethinking the foundation of human rights as a core of European identity, it's one of the most important challenges for the Europeans. And I think that we should start with the idea of human dignity, of course not changing it, but give it a new interpretation. And I would like to appeal to Ronald Dworkin's proposal from the beginning of the 21st century. this concept that Ronald Dworkin described in his book entitled "Is Democracy Possible Here?" This book was published in 2008 when politics in America were deeply polarized, perhaps as never before. In Congress, the media, the academic debate, the opponents from right and left struggle against one another as if politics were contact sports played with the shout of cheerleaders, as well as today because the Dworkinian concept wasn't accepted. Ronald Dworkin writes that US had a deeply depressing political culture, like in Europe nowadays. And what can we change? Ronald Dworkin lays out two core principles that citizens should share. First, that each human life is intrinsically and equally valuable. This is the first about the human dignity. And second, that each person has an inalienable personal responsibility for identifying and realizing value in his or her own life. And then Dworkin shows what fidelity to these principles would mean for human rights, the place of religious in public life, economic justice, and the character and value of democracy. The basic aim is to convince Europeans that they can and must defend their own convictions through their own interpretation of these shared values at any level. And that's all. Thank you.
Thank you very much for I infringed my own rules. So, thank you very much for a very interesting presentation. And I already have several questions set because it's this is, I believe, the discussion on the human dignity is the cornerstone, and the concept of the human dignity in terms of the common values we share. So. But we have to move forward. Unfortunately, we will come back to these questions a bit later during the discussions. And I would like to ask now Professor Barbara Melnik from the University of Wrocław, again representing, as it was very accurately pointed out, Eastern Europe, to talk about citizenship of European Union as also a question of identity, as the phenomenon or set of rules or whatever that appeared with the birth of European Union, and at least people in Europe, in Eastern Europe, which I can assure, understand that this set of rules is very important, as a very important tool for not only for as being part of European Union, but also representing them as Europeans. So the floor is yours.
Thank you very much. I would like to thank, first of all, the WISE program for the organizing this conference, and the Charles University in Prague for hosting us all here, because it's a great pleasure just to be here and have the possibility to exchange some ideas about European integration as such, and about this, what we think about the European Union. Is it okay? Yes. Yes. So I'm not talking very loud, so it's okay. But coming back to the core, to the main problem of my presentation, citizenship of the EU, question of identity. I think that we ought to start maybe from the beginning. So European Union citizenship was established by Maastricht Treaty in 1992. We generally know the rights which were granted by the treaty establishing the European Union, and of course then it was in the Treaty on the European Community, not in the European Union. Then we have a small small or not small, that depends on the point of view that we are taking. Then we have the development of rights of citizens. We have some additional rights from this basic rights, which were more or less the collection of that rights which already existed in the treaties establishing European Economic Community, because we've got political rights as voting and standing in the European election. We've got freedom of movement, which was developed in the 80s by Schengen Treaty. We've got for workers, but not only for workers, we've got some additional documents which were accepted since 70s. Then, of course, we've got some ideas about the improvement of this freedom of movement by the common pattern of passports. We've got common pattern of driving license as well. So more or less some progress was started in the 70s after the Tindemans report was presented, and then this building of union closer to citizens, it was developed. Then we have of course new rights, which was the establishment of the Ombudsman office in the European Union. We've got we've got also election in regional voting to municipal government. What was new in Amsterdam Treaty? First of all, right to information. So it was developed, and then the whole discussion started, a new discussion started, because it was the problem how to develop European Union closer to citizen, how to build this identity, not based only on economic rights, as it used to be. I would like to remind you just my favorite sentence from the European integration, that individual was recognized as active economic element of the integration, not a human being, not a person, not an individual, but economic element. So it was quite for us interesting, but also it was the understanding of person through its rights, economic rights in the European Union. Then we've got a great debate which started during 70s, what to do with human rights in the European Union. Of course, there were three visions which were accepted in the end: to build own fundamental rights, to create own documents on fundamental rights, or to accept European Convention on Human Rights. More or less, we can observe that both, there were no distinction between them, and now we are developed in this direction that all three ways were accepted, because we've got European citizenship, we've got the Charter on Fundamental Rights, and we've got the possibility that court has a different idea, but we had the opportunity, the possibility to join European Convention. So all together. So there is no common vision. Altogether, just to accept all vision, and everyone will be happy. It was the solution, which was quite disappointing for many persons. And politicians as well. So then, at the beginning of the new century, it was the work on the Charter of Fundamental Rights for European Union, and then the collapse of the Constitutional Treaty, and then Lisbon Treaty as a new solution for Europeans, and something new appeared. I mean, citizens' initiative, quite important right for citizens when they can prepare a draft project for new legal acts in the European Union, to be much more involved, as it used to be, in the process of legislation in the European Union. But what was the creation of the European Union, and does it help? We can ask if it did help the identity, the European identity, or development of the European Union. We have to go back to the 90s, and first it was the idea to establish European Union citizenship as something which make citizens, individuals, closer to the European Union, just to give individuals some common rights, common values to share, which will be based on this link between organization and individual. Of course, it was something new, because traditional citizenship used to be recognized as a legal link between state and individual. Now we've got strange link or new link international organization, individual. Even if we compare it with this famous definition of citizens' rights, which was presented by Marshall, we can find that there are quite similar. There are some fields which are almost the same or similar to that which was granted by Marshall, because we've got a private rights treaty, of course, secure this field of individuals' activity. Then we've got political rights, we've got standing and voting in European election and regional election, and then we've got social rights. And social phase of the European community was successfully developed since 70s. It just came with the whole set of rules connecting with freedom of movements of workers. So in this field there were some success, of course some failures as well, because we know the history of the Charter of Social Rights, of worker and social rights in the European Union. But anyway, there were some steps, there were some improvements, there were some common decisions, and the whole set of legal acts which were accepted. So we can say more or less Marshall would be satisfied by this, what happened in the European Union. Of course, this political aspect was not so well developed as it is supposed to be, for the reason of some differences between European states. But first steps towards this aim were made. How it was understood and how just the European identity was created. First, when we are back in the 90s, we can say that the establishment of the European citizenship was the end of the era of this element economically active, to individual human being, a person, a citizen, individual who possessed some rights. No obligations were mentioned, of course. It was quite comfortable, but majority of documents which are focused on human rights, they only mention some obligations, but very rare they defined them. So European Union followed this tradition. So it was one element of this of the whole process. Then we've got the new beginning, and something which was supposed to build European identity was divide nations as such. We can observe that in the process of ratification of Maastricht Treaty. On the one hand, we've got something what strengthened the position of individual. On the other hand, we've got the threat. It's the end of national state. What will be next? Where European Union is really going, what politicians are thinking about. They just decided about our future, our political status, establishing European Union citizenship, without any consensus, without any discussion. It's just a political decision made by force. Political decision without any consultations with public opinion. It was something which is granted, which we ought to just be. After the Maastricht Treaty, we ought to be very happy, but we are not. We are confused. We do not know what to do with that, as a matter of fact, because we are lost. We were not informed about it. We haven't got enough time to build some common values, to build this feeling of community, and now we are citizens of the European Union. What does it mean? Some discussion connected with Danish position. Some discussion which has a very strong discussion, which has its roots in a great discussion in old members of the European Union, even about it. It was quite interesting to observe it when we've got this special agreement between European Union and Denmark, which just underlined that European citizenship does not replace national citizenship. And what happened next? We've got the same sentence in the Amsterdam Treaty. So we can notice it was very important. Someone has forgotten about something in the debate about future of the European citizens. So it was something which was not commonly accepted. For scholars, of course, for elite of the society, it was something good, but for a common person to be a citizen of the European Union, it was something which was problematic. And of course, there was a threat that the European Union will replace states and will build a new legal order, federal state, or anything like that. Maybe a threat, maybe a hope. That depends which position we will take, of course, in this debate. But anyway, it was something to be discussed, and we can observe that the Court of Justice of the European Union, European Communities, European Union, was also very careful at the beginning when I was focused on the European Union citizenship, because I prepared it was a long time ago, I prepared my PhD on that subject. Since 1991, as a matter of fact, there was no judgment on the Court of Justice which directly said that this right of individual is based on the citizenship of the European Union. Then we have a judgment, but at the beginning of the case was in 1999, but the verdict was taken a little later than it used to be. Before that date, we've got 7 years of the European Union citizenship and no judgment which will say directly what the European citizenship really is and how those provisions of the treaty may influence the position of individuals as such in the European area. So also it is interesting to observe that process. But how to build this common identity and how to solve this problem? Of course, there are many ideas, and even we can think if something like European identity exists. Because since 2004, when new member states joined the European Union, we can observe a different approach to the European integration. Some authors stress that new member states, the position of new member states is similar to that which was, which is, or it was presented by Great Britain, that we ought to focus on the economic integration. Is this aspect which is the most important for us? And we shouldn't analyze other aspects of integration because this other aspects is a threat of our national identity. This approach, unfortunately, was presented by politicians, but also I noticed something interesting, that European Union is treated as something framed. That means that we said, not we have decided inside the European Union, in the framework of European, but they decided something, or they decide something in Brussels. We have nothing to do with that. We are not sending our representatives there, our government is not present during the debate, they do not present any common idea, they decided something in Brussels. So Commission, Council, they are just artificial bodies without any national roots, if we just observe and if we analyze the European Union as an international organization as such. So it's quite interesting approach. Something framed, something which is not familiar with our tradition, with the position of the state, national state. Of course, we can criticize it, we can just analyze it, where are roots of that approach. But it's just a fact. We cannot just discuss with facts and with this language which is used in media, in many official political debate in member states as such. Always European Union is something different, something which is very useful for us, for our purpose, but maybe we will not totally identify with this project because we are not sure where this project is really leading us. So that's the question of identity. And of course there were some ideas how to build it. Some of that ideas we can say are already finished. We can say they ended for the reason that this stage of integration is already over. So first, to build economic integration, we can say more or less this aim is already achieved. So it was just the first. And this approach was presented by some states, as for example Great Britain. Now the position of the Great Britain is just a little different, let me say like that, because of course it may lead somewhere, but still there is a debate because the government already settled the date of when the negotiation ought to start it, but we will see what will be in the future. And of course, this approach is presented by Scandinavian states as such. more or less, and new members which joined the European Union in 2004. Then we have the second approach, which is represented by the core of the European Union, Germany, mainly Germany, France, of course, Italy, Benelux states together, that Union is not only economic integration, but also some values which ought to be shared, and this aim might be achieved by legal process inside the European Union to accept common law, common regulations, and thanks to that we will achieve common European identity because we are sharing the same rights, the same values on this international level or European level. Then it's the idea to create a European identity. In short, maybe it's not a very elegant sentence, but by force. That means that do not ask anyone about this, what ought to happen or may happen, but to accept legal rights. Do not consultate that with citizens. We know better what is good for them. And some authors stressed that this approach sometimes is presented by European institutions as well as philosophers, scientists, and so on. So we know the solution, we propose something, and we do not analyze, as a matter of fact, this individual or populistic factor. We just accept it. We know what is better. We know the common end, the common good, how it ought to be achieved. And in the same moment, we've got another approach to build this identity through strengthening the European Union as a political actor, as a political international actor, political entity, which will be present in international relations, very active in international relations, and that may lead to the building of the common, better, secure future, because we can secure our rights on the international level and on internal level as the result of actions which are taken. Now, what we can say, just to sum up, because I promised I will not violate the time, so to sum up some ideas about the identity of the European Union. We, as a Europeans and European Union, has a great problem with identity. This identity is not built. We share some values, but more or less those values are treated differently. They are treated as some privileges. That we can move freely, that we can just live in every state of the European Union, more or less, that we are internationally protected. So that's something good. But when we are coming to the core of that problem, it is very difficult to define what this being European really mean. Every state all citizens of that state would propose something different, something which more or less cannot be accepted by other states. Because, for example, of Poland, we can say we can offer to this European identity our Christianity. So, for example, for like state as France, they will say, okay, we are turning back to the 18th or 19th century, what we are talking about. We will say Christianity as a set of values. Okay, then we can discuss about the values, but not about Christianity as such. So it's just a different approach which we ought to distinguish, and I think that it's a great problem to build, and there are more questions than answers, because now we've got a problem, we've got a crisis. We can just divide European Union in those who are rich and those who are poor. So it's very bad for building a common future, because we are saying Greece has an economical problem, so now richer European states say we have to pay for them. The citizens are feeling we have to waste our money for someone else. So it's a great problem with identity, but also with the building of common feeling of being Europeans as such. The solution is known, as a matter of fact, because if we accept even one of this point, one of the fourth points which I have already presented, we can see that there are some weakness in that ideas, and how to solve it We can just only observe where the process of integration will lead and how the problems will be solved. So thank you very much for your attention. Once again.
Thank you very much, Professor Melnik. I have a lot of questions to ask, but and we are starting the discussions with the presenters. So now what we will do, we have only these people who are visible for direct broadcast. So I will just move with the micro, okay? Okay. So where are the questions? Okay, we have two people.
Thank you very much to all the presenters for your presentations. My name is Dr. Paresh Kathrani, and I come from the University of Westminster in London. I'd like to pose a general question to all three presenters, if I may. And looking at the theme of the plenary session, in search of a European identity, the notion of a search for a European identity is a strong temporal aspect, a strong time aspect, in terms of looking to the future. What will our identity be? What is our identity now? We're trying to find it. What will our identity be in the future? So there's a strong temporal aspect. It's a forward-looking concept. The notion of an identity, who I am today, is a forward-looking concept. Who will I be tomorrow? So that's a strong temporal aspect. But I wonder to what extent the problem lies in the fact that the EU isn't a very forward-looking organization. It's always either now-looking or has been backward-looking. If one goes back to the very genesis or beginning of the European, the EEC, or the roots of the organization, it was set up as a response to what had happened during the Second World War. It was backward-looking. It was trying to resolve a crisis. Similarly, all the significant milestones of the European Union have been arguably backward-looking. One looks at the merger treaties, one looks at the Treaty of Maastricht, what's happening in the 1990s with the end of the Cold War. One looks at the Treaty of Lisbon with the European enlargement in the 2000s. So it's always been an organization that's been rooted in the now, trying to resolve problems, trying to define its identity, not for the future, but its identity given the fracture or the turmoils that it's been through at that moment in time. And one can see that right now, for example, with the treatment of refugees. Mikhail talked about human dignity. The thing about human dignity is, again, it's a forward-looking concept. We're trying to define, well, what is our dignity? How should we move forward? But again, the EU takes a very backward approach to human dignity, a very crisis management approach. In the refugee crisis, for example, there is a crisis that's going on in Europe right now. We're trying to define, well, how do we take a dignity or human rights-based approach to refugees? But what we're trying to do is we're trying to say, well, this is a problem, so we need to work out what human dignity is in relation to that problem now. What is the best way to treat them now, as opposed to, well, how do we treat them best in the future? So even our approach to refugees today is very much centered on how do we deal with this crisis right now, as opposed to for the future. So my question would be, going back to the beginning, this notion of in search of an identity, will it be a perpetual search? Is it a search that can never be fulfilled because of the very philosophy, the very essence of what the EU is? It's a crisis management organization. It's always trying to resolve problems that have occurred in the past, and it can never look to the future because it can never come out of this hole of being a crisis management organization. So it's a search that will continue because it's an organization that isn't built to answer that search. It isn't built for the future, it's built for the past.
Thank you very much. I'm Giovanni Carlo Bruno from the National Research Council of Italy. I got a couple of questions, I would say questions, observation on the interventions, very detailed and interesting. So they raise some curiosity to me, and also I try to open a question which probably doesn't have an answer, but just to add some question, as Professor Milnik said at the end of her intervention. The first one concerns democracy. So the will of people in reimagining the role of the EU. Well, it opens up an endless, I think, discussion on whether the will of people, which, as you said repeatedly, was not considered in the moment in which the EU was shaped, was organized, was changed. It was taken into account and reshaped into a more complex, as it always is in democracies, I would say. So I really wonder how this will be managed for the future of the EU. The second, and I'm still referring to Mr. Urbacic's intervention, Professor Urbacic's intervention, refers to the human rights as a core of the EU values. Let's try to see what happened in the very long process of the EU accession to European Convention on Human Rights. If we go through the opinion of December 2014, I would say that we see a certain resistance to be, I would say, soft, of the Luxembourg Court in admitting what is admitted by superior courts within states. The Luxembourg Court said, anyway, the last word on fundamental rights is ours, because we are the interpreters of the legal system of the EU. If this had been said by, I don't know, Italian Constitutional Court or French Conseil Constitutionnel or German Bundesverfassungsgericht, this would have created much more discussion. So, since we are discussing the contemporary values of the EU, we should be ready also to put on the table some as an outcome, I would say, also some remarks on this process. The separation of the legal orders is remaining, I would say, a cornerstone of the system which impedes the EU to access to the European Convention on Human Rights. And then to go directly to the issue of Professor Milnik, that is citizenship. I don't know why it was chosen for the treaties to call citizenship the extension of consular rights to countries for EU citizens. That was the citizenship, the national citizenship. I would say that this is a mix of, as you said, political choice, being conscious that something had to change to let the EU be closer to people, but at the same time it created more confusion in the use of certain terms which are settled in the Western tradition, in the legal tradition of states. I would not say the Western one. So it created, according to my humble opinion, more problems than solutions. So, and I don't have, as I said at the beginning, any solution to that. Thank you very much.
any other questions? So then I have a question for every speaker. So the first question to Professor Kuklin. You were mentioning that the Second World War just showed that the concept of national state was very strong and very important. And now we see certain tendencies of coming back to that. One of the core of our project is to analyze whether we are not repeating the same mistakes and what leads to the repetition of history. Do you see any tendencies that this nation, the concept of national state will get stronger in terms of what's happening now? And what could be done in order to avoid, while learning the lessons of the history, to avoid any big crisis like the crisis that we had in 50s. Now the question to Professor Urbanchik. It was very interesting to hear that you are mentioning Christianity as one of the founding stones of European community, and then it raises a question to me, looking at other countries that have let's say at the moment they have like a very mixed structure in terms of religion. And the question then, which was already the issue that was already raised by Professor Melnik, is to a certain extent, can we have shared values, or can we have common values? Or at the moment having such a complexity, we can only come with shared values. Because for me, these terms are different, like common and or only shared, which makes a difference. And the question to Professor Mielnik. So it's very interesting. I thought of the terms that were used since the birth of the community. So in the beginning we had European Economic Community, then we had European Community, and from the start, so it seems that we had to get used to that term of European Community, but I'm wondering whether people thought of what that means. And then when we started with citizenship, we started talking about Community of Europeans, which is, well, union also, but then the most important thing was Community of Europeans, which had to accept or not the European citizens, European citizenship. And the question is, what is your evaluation as of today? Is the Community of Europeans mature enough to accept the citizenship in comparison to what we have back in 90s? And then if it is already mature, what was the main factor that led to this maturity?
I think this question of some kind of revival of the idea of national state and using sometimes these historical arguments, what you mentioned, that if we are going to repeat some mistakes from the 40s or 50s, I think that the situation is of course different, but I think it's a very good example how the history is sometimes used for the contemporary problems, and of course it's also interrelated with this question about what is the role for the European Union, if it is solving the problems from the past, if it is trying to manage the problems or current problems, and if there is some vision for the future. I think that when you see the discussion within, let's say, within the Czech society, I can show you on this example. I think it's a very good interrelation, because if you see European Union only as an institution for solving current problems, and there are problems, and of course some solutions are not ideal, and it's quite difficult to find a compromise within the European Union. Then of course you can see that such view for European Union strengthen those forces within the societies who are trying to for example, use these ideas of strong national states, let's say, connected with nationalism, connected with also looking for the past, sometimes some great past of the nations, connected with, of course, some bizarre ideas, how long traditions you have. You know, this is for another discussion. But I think this is very important, because then you have to come with some ideas for the European Union for the future prospect. I think that, for example, the debate before Brexit, this is a very good example, because if you concentrate only on problems or only on current affairs, and for example, you didn't mention even some good results, but for both sides. I think that I was quite surprised that even those who were for voting for, they didn't mention some real advantages of the European Union, not only current but for the future. And I think it's a very good question. So I think that I will see this interrelation of these problems. But on the other hand, I think that we cannot overcome past easily, and I think that it's very important to carefully analyze also the developments from the past. For example, then you can see that of course different regions or different states within the European Union can view similar problems differently because of their different past memories, and this is really necessary to take into account and to find some policies how to overcome it, and it's connected with the future prospect again. So I'm not. I try to be optimistic, but I think that it's extremely difficult, and I think that we are also missing some real leaders for the future. That's another problem. And I think that's a kind of a crisis of traditional politics. I think you can easily find many aspects of that, especially again in Central Europe. And if you have real leaders, they are usually not the leaders for the prospect of European Union. That's another problem. But again, I know it's more problematic or more complex. But I think it was a very good point for this kind of a revival of national states, using also some historical arguments.
Thank you very much for all the questions. I hope that I will answer. And first of all, maybe I will answer to the question from the parish and the first question from the Professor Bruno. Well, maybe it's a more general problem about how the European Union works. And I agree with you that it's the reactive policy. Maybe we should stop looking back and we should start looking in the future. The problem of the future of the EU, maybe there is no general aim, a great project. We can laugh about the Americans, but they always saying that they want to promote the American value. They want to promote the democracy. It doesn't work. But this is the idea. This is the idea, and maybe this could be example for the EU. You're right that there is no active politics connected with the refugee crisis. There is only a reactive. For example, well, the Europe don't do anything in Syria. This is the main problem of the refugee crisis. In Syria are Americans, in Syria are Russians, but there is no European politics towards Syria. So maybe promoting some European values. I'm not a lawyer. I'm not a specialist of the international law, so it's hard to me to answer the questions about the institutional conflict, what the Professor Bruno said, between the Luxembourg and the national courts. I'm trying to escape from this kind of this. I know that this could be silly, but I'm trying to deal with the ideas and with the concept. I don't think that the European identity can be made from the top because of the law of the citizenship. For me, it doesn't work this way. The group identity is always created from the bottom, and we can see it in Eastern Europe. I know maybe Italian experience are quite different.
Maybe we can continue later.
Okay. I'm open to discuss it because it's my speech was some general remarks and no hard opinions. And I agree that the separation of power is a cornerstone of democracy. I'm very critical to Polish government and what they do with the Constitutional Court. But for example, in EU, there is no separation of power at all. There is no balance of power at all when we see the institutional. Maybe because European Union isn't a state. It's just an organization. What about the role of the Christianity? I think that my opinion is we shouldn't forget about the roots. It doesn't mean that we should promote the Catholic teaching about marriage or abortion. This is the two completely different point of view. But we cannot forget about the roots of some ideas. For example, the equality of all people. It's not only rooted in Christianity, of course, because we have the philosophy of Greece. But we just have to remember about the roots, and that's all. That's all. Thank you.
It's very difficult to answer some questions because some answers may cost another questions. So it's just, I think, typical. But something what just was striking for me, when we can find the European identity, it's very difficult to ask, because when I made some researches on this topic, I just also find some ideas and some examples. Maybe it's not the best, I'm not a specialist in that area, that in some dimension, I will not agree with Professor Reimagining, that in some dimension, sometimes it works when we are creating something, we're creating identity through law. That's maybe I'm a lawyer. Maybe for that reason that I'm a lawyer, I'm a little, just a strange person. But anyway, just to establish common rules for the society. Of course, we have to remember about the will of the society. But sometimes the will of one group in one part of the state could be totally different than the idea, the will of another part of the citizens or population of that state. We have to remember about it, and that's the aim, the purpose, the goal of the government, generally government, authority, maybe it's a better word, authority, to find this golden center and to suggest something which may be accepted by both sides or by whole Europe in our example. Because when we are thinking about the identity of the European Union and of the European integration, maybe it might be a little bitter remark, but we have to remember what was at the beginning. At the beginning was the end of the Second World War. tragic experience, drastic experience when the human being was worth nothing, as a matter of fact. This experience just shocked some political elites. They wanted to change something, change the approach to that. They knew the failure of ideas of the European integrity which was presented before the Second World War. And they said, maybe through economy. That would be something what would be easier to be understood. And for that reason, let's build it that way. Second, what kept Europe, Western Europe, together was Cold War, and was Soviet Union, not Russia, Soviet Union. At the beginning of 90s, it was just the idea, it was the end of the Cold War. We felt free. We ought to do something new. We ought to improve our work. And then the process, the problem started, because the idea of doing something better, go to the future, build something new, was clashed with this what was in the past. And the idea about integration and the feeling of integration, which was presented by people, common people. We have to remember that we are talking about the European integration, about great advantages, great challenges. But we have to remember that the number of persons who are really using those rights is limited. It's in general, it is common. Everyone can. But as a matter of fact, not everyone is doing that. There are some persons who never cross the border of their own country. They are very close to the regions they are living. They have different purpose, different problem in that regions. They are not taking care, not even about the European Union, but about next regional municipality. So it is a problem, maybe not a problem, but we ought to remember about it. That some ideas about greater integration, closer integration, could be recognized as a possible threat to the changing of our lifestyle. So it is a problem. It is very difficult to find the solution for that. Also, you just asked me, it was one it was one of the aspects of the questions that you have asked, that European Union, it was a mistake that they use the traditional terms which are known in national law on the international level, on the European Union level. It is true, but what to do? There were lawyers, there were politicians, they didn't discover anything new. Of course, it is misleading. It is misleading because citizenship problem, it's only something additional, not something what existed from the beginning. So it's just the first. So it's one of the questions. And something what came into my mind, but also was recognized by scientists before, that the European Union citizenship created also new type of persons in the European Union, citizens and foreigners. That means that we are European Union citizens, or even the first idea was to call this institution European citizenship. Then they decided to change it into European Union citizenship as such. But it was the creation of new entity, new person, and foreigner, person who is from abroad, not from another EU member state, but from non-European state. Not European Union states. That a person who is who is a foreigner and who is treated as a foreigner because those persons cannot join the rights which are guaranteed by treaty establishing European Union. So we've got another differentiation inside European Union as an international organization, in my opinion. And the question of Regina about the nature and if the European citizenship is the project which could be treated as something which was already achieved. I think that in some level, yes, it is. But on the other hand, it is not. We've got two sides of the same coin. That means on the one hand we will say we are European, we are members of the European Union. On the other hand, we will say not exactly we are the same, not exactly we have the same feeling, not exactly we have the same approach. Of course, crisis of refugees, problem of refugees is mentioned because it's one of the very drastic example how we recognize foreigners, how we recognize other persons when they have a problem. In Poland, in the Polish situation, honestly speaking, I have a great problem, to be honest, because we are the nation of refugees. In the 19th century, we can say that we can send Poland didn't exist, of course, but our nationals, well, all around the world. We were fighting for independence, for freedom of other nation. We can say that we export what was the best in our society abroad. Maybe not the best, but something which has some ideas, and they fight with inequality for freedom of even. We have a very good slogan for yours and our freedom. So it's just one of the Polish very important. I don't know how to name it even. Slogan, not also, but the feelings that we have this vision of the world. Then, after in the period between two wars, the Polish state was re-established. So we have different feelings about the result and about the process. This what happened during the First World War, then Western Europe. For us, it was something good. It seems to be strange because Poland was re-established. It was not a tragedy, it was a tragedy, but it was a tragedy in the world dimension. For Poland it was something good, because other states were weaker and we could re-establish our statehood. Then we've got the Second World War, we've got also the flows of refugees after the war, during the war, after the war. Then Cold War. Also, many persons ran away from Poland for the reason for political reasons, for other reasons, for economic reasons. We can multiply the examples what happened. And now we have this approach to refugees that we are not welcoming there. So for me, it's something strange because when we are talking about the refugees from Poland, we say, oh yes, it might happen, it was a tragedy. But when we compare it with that, what happened in that region, from which those persons are coming, then we say it was nothing if we compare it with the Polish situation in the past. So it is confusing, as a matter of fact. It is confusing that we do not remember about our past, about how we justified our actions, the actions of Polish citizens, and now what is the approach to that problem and the problem of the European Union. What could be the solution, and what could be, of course, some changes in the European Union, it will be also a term, slogan, we can use several names, some things ought to be changed, some reforms are necessary. In what direction? From my point of view, as a person who is interested in public international law, European law, I can say as close as possible. That's my answer. But for example, for politicians, it's impossible. They won the election. They won the position on the national interest in the European Union. They do not want their position on this, that they will say, we want something in the European Union. We just built our strong position. No, they say, we protest against this, what European Union proposed. That's a difference which is very, very important and which is visible in my opinion. So thank you very much. I was talking to myself. Sorry.
I don't want to comment the Polish politic about the refugees crisis, but I have to admit that in Poland there are thousands of Ukrainians.
But they are not refugees, as a
They are
matter
not
of fact.
refugees, but it's not like this that we don't want to live with another people and we want to close our borders at all. We have to remember that the Polish society is strictly homological, and now this is a completely new experience. And so this is only one.
Sorry, just one remark. It's a new experience after the Second World War. Before the Second World War, we used to live in multinational states. So also it's another problem for Eastern Europe, I think, that we were closed states, that the flow of information was impossible. And that's the reason why we have this much more nationalistic approach than European, Western European states. I think that this is also a part of the answer.
I just have a very quick follow-up comment to what I said about the European Union being a backward-looking crisis management organisation, possibly. It occurs whether what would have happened if the European Union had taken a conflict and resolution approach that we see today, truth and reconciliation. Maybe if back in the 1950s they'd gone through a process of truth and reconciliation, like many countries have today, who knows what the future would have held. Maybe they would have resolved issues which currently keep on cropping up. And so therefore, rather than being a sort of crisis management, problem-resolving organisation, maybe could have been forward-looking if we had gone through a process of truth and reconciliation, like other countries have. Just a thought.
Yeah.
So thank you very much for all the questions, for all the answers, and I believe that we're still eager to continue the discussion, but we have to move on, and coffee is waiting for us, and we are waiting for the coffee very much. So we are coming back in 15 minutes and with the second session.
If the Polish government is here.
Push it a little bit longer. Push and hold for a few seconds. No?
It's easier. Thank you very much.
Sorry.
I mean, nothing. Section also. But we put ourselves out of the hiding from the camera. Okay, so I'm safe there. I checked the camera and I realized that part of the signal was my head. With hair. Well, and my nephew texted me and said, well, we only see your head. Everywhere.
Nobody complained that the people weren't here.
We will need to rearrange the table so that the speakers are
Yes. I want to interrupt you too much because I feel the discussion about discussing with colleagues, but stop me if you think.
Să era ce? Ce? Šitas ar įkelti ant Šitas. Arkivis Tomas.
And could you please help?
Once again. This right. This one. You think so? This one? So I'll leave it.
Yes, I will be the last.
Okay. Just a second. Yeah.
Could I?
Thank you.
Thank you.
You're welcome.
So, good morning still, once again. Now we will come to another panel, another plenary session, and we'll discuss the questions connecting with European Union, a vision of visionary. And I think that it seems to be quite interesting for the position of the European Union in the world as an international actor, international person who is operating in the international area in some different and changing, very dynamic society and very dynamic community all around the world. So the first person who will take a floor is Dr. Paresh Kathrani. So please.
Thank you, Barbara. And can I also thank Regina for convening this conference, and also David and the Charles University for hosting it. So my gratitude to everyone. Thank you very much. My name is Dr. Paresh Kathrani, and I am a lecturer from the University of Westminster in London. And it's a pleasure for me today to be talking to you about the following title: Consensus or Relativity, the Approach of the European Union to Humanitarian Aid. I'd like to begin by posing a question, if I may, and that question is, what is the European Union? I mean, when we talk about the EU, what is it as an entity? And I suppose we can approach it from many different frameworks. It's a political union which provides a forum for member states to come together and discuss and resolve certain issues of importance to them. It's a legal union. Of course, it consists of a body of intricate laws, from the treaties down to directives and other forms of law, which provide an element of regulation of certain competencies. It's an economic union. Of course, it aspires to certain economic objectives. It's a cultural union of people with a common shared value and a common shared heritage. So it can be looked at from many different frameworks. I would posit for my presentation today that another way in which the European Union can be understood is, of course, as an ethical union. It's an ethical union defined as a body of values. We can take it down to the level and say what the European Union is a collection of member states, of leaders, of people, of citizens who aspire or share common values, common ethical values. And in this context, I would define a value as an ideal that influences the course of action. The European Union as an entity has certain values which it subscribes to and which shape its policy agenda. And here I would like to raise another important concept, the concept of values before law. Often, when we are thinking about the European Union, we look at it purely legally, in terms of positive law. It, of course, consists of treaties and a whole system of norms, a hierarchy of norms, which are applied on a day-to-day basis, both by its institutions, its members, and more particularly by its court. And it provides us with a space in which to discuss and come to decisions or resolutions based upon those norms. And what the European Union tends to do, it tends to take a very formalistic and very positivist approach to the law, in terms of a very black letter approach. Here is the rule, here is what it means, and here is what we must discuss. But I would say that what precedes that, what should precede the application of law is an attitude. I take more of a moralistic or a natural law approach to law as opposed to a hard formal approach. I say that what precedes the application of law is the attitude. Unless one has a good attitude, one cannot be a good lawyer, to put it bluntly. So one has to begin with a certain value or ethic within oneself, an attitude, and then that motivates how they approach the law. And my support for this proposition is, of course, that the very genesis or foundation of the EU lays in values. If you go back to Schumann's declaration before the foundation of the European coal and steel community, what Schuman was saying was, look, we've been through the Second World War, we want to avoid this tragedy ever happening again, let's work together in solidarity around these two particular industries. That was a value. The European Union started as a value, which then gave rise to the law. So values come before the law. Values must be understood before all else, and by a value I mean an attitude of, let's work from the same page here. Or the notion of first ethics, that first the ethics come and then the law. And my support for this, the idea that values precede the law, of course has been expressed, can be found in many different sources. For example, Article 2 of the Treaty of Rome says that the community shall have it as its task, by establishing a common market and progressively approximating the economic policies of the member states, to promote throughout the community harmonious development of economic activities, etc. What I've done there is highlighted in red the values of the European Union, of the EEC, when it was established in 1957. It talks about a common market, approximating economic policies, a harmonious development, stability, standards of living, closer relations. All of those were aspirations and values which preceded the institution or the institutions of the EU, a philosophy, an ethos. Let's do this together. Similarly, even more clearly, Article 2 of the Treaty of Lisbon 2007 puts it even more bluntly, or more clearly. The Union is founded on the values of respect for human dignity, freedom, democracy, equality, the rule of law, and respect for human rights. Now, what approach do we take? Do we say first the law and then the values, or do we say first the values and then the law? I would say that it has to be a value-led approach to start with. If we say first the law and then the values, then we instrumentalize the law. The law by its very nature gives rise to disagreements as to what the law should be. So we start off, if we say first the law and then the values, we'll use the law to achieve the values. Then we start off with this whole sort of discussion and debate as to what the law is, and we don't even reach the values. Whereas if we begin with the values first, this common attitude that, look, we all aspire to human dignity, freedom, democracy, and then let's use a law to instrumentalize that, then that might be probably the best approach to take. And that's the approach that the European Union envisaged, when it said, let's avoid conflict, let's build a law. Value of avoiding conflict came first, and then the law afterwards. Now, I just want to interrogate this notion, ethical notion, a bit further very quickly. When I'm saying to you that the European Union is an ethical union, a union made up of common values, I am not saying to you, of course, that all member states agree on what these values are. For me saying that's an ethical union, I'm not being idealistic. I'm not saying that they all agree on what these values are. While the EU may have common values, the emphasis that the organization and its member states place on each of those will differ. Everyone subscribes to human rights, democracy, rule of law, but of course what they understand by those concepts is different. So what the EU is a zone of complexity. It's a meeting ground to say, well, let's try and flesh out or work out what these values are. What is democracy? What is rule of law? What is human rights? It's a place in which to discuss these various issues through a legal framework, and of course, its institutions provided with the forum to discuss these matters. So it's an ethical union of shared values which provide a framework for discussion, debate, and its institutions provided with fora. That's my theory. So shared values, expressed through law, debated through institutions. Now I come on to the EU consensus on humanitarian aid. And my hypothesis, with which I'll spend the second part of my presentation, is that there is something quite paradoxical about using the word consensus in this particular context. I think the use of this word, consensus, in conjunction with humanitarian aid, can come across as quite paradoxical. Let me explain. First of all, what is the EU consensus on humanitarian aid? I'll give you a brief run-through. It's a consensus, it's an approach that was adopted in 2007 on how humanitarian aid ought to be distributed, how it ought to be actioned. Paragraph 1 of the consensus says humanitarian aid is a fundamental expression of universal value of solidarity between people and a moral imperative. Again, look at the words: expression, solidarity, moral imperative. Those are normative concepts. And so that's the approach towards fundamental approach towards humanitarian aid, being a moral imperative, etc. It talks about aid in the context of man-made and natural disasters, war, conflict, famine. How can we help alleviate suffering in these contexts? It lays down principles for alleviating suffering through the provision of humanitarian aid. Principles such as put humanity at the forefront, be neutral in the distribution of aid with regards to man-made and natural disasters, do not take a particular side, be impartial, look at needs, and of course humanitarian aid is an independent objective irrespective of other objectives such as security and military objectives. And to orchestrate this granting or this policy of humanitarian aid around these principles, we have, of course, the Directorate General for the European Civil Protection and Humanitarian Aid Operations at the European Commission. Now, I wish to look at or examine this notion of a consensus. Now, when I use the word consensus, when I say we have a consensus, it has a strong moral connotation. I could say to you, we have a framework. I could say to you, we have an agreement. I could say to you, I can't see it, but I could say to you that we have a consensus. Word consensus, the word framework, the word agreement, the word understanding, all of these suggest a meeting of the minds. But yet they're all different words and they all have different connotations. The word consensus, to say we have a consensus, suggests solidarity, has a strong moral connotation to it. It suggests an agreement in spirit. We're united in our thoughts. We have an agreement in spirit about something. And as I say, it can be contrasted with the word framework. Now, when we add this word consensus to other concepts, such as we have a consensus on humanitarian aid, that suggests that there is a very strong agreement, an accordance, in terms of how one should approach humanitarian aid. If I said to you that we have a framework on humanitarian aid, that has a whole different emphasis than the words, we have a consensus on humanitarian aid. A framework is a lot looser term than consensus. A consensus on humanitarian aid suggests we are united in spirit in terms of our approach to humanitarian aid. And this idea of a strong consensus or spirit on humanitarian aid is backed up by words used in the consensus itself. It's a consensus because we share the expression of universal value of solidarity between people and a moral imperative. It's a strong commitment based upon strong normative grounds. And when you add to that what humanitarian aid actually is, humanitarian aid is given to people in desperate need, either because of conflict, war, famine, other serious suffering. To say that we have a consensus on that suggests we have a strong agreement in spirit on how to alleviate your suffering. So, my thesis is that the notion of a European consensus in humanitarian aid can be quite paradoxical, because it's not a consensus at all. The use of the word consensus doesn't quite fit in with the zone of complexity that I posited at the very beginning. That's not to say that the EU hasn't achieved very good things in the field of humanitarian aid. There are many examples of good things that the European Union is currently doing when it comes to humanitarian aid. Article 214 of the Lisbon Treaty puts humanitarian aid on a policy footing and says humanitarian aid is a policy in itself, which is a fantastic thing. We have the Director General, a specific body at the European, an agency at the European Commission which orchestrates humanitarian aid. We have programs such as humanitarian aid, civil protection, disaster reduction, disaster risk reduction. The ECHO agency has many partnerships and agreements with the United Nations, with NGOs to alleviate, to orchestrate humanitarian aid. And of course, the European Union is the largest single donor. How much time do I have left, please? 3 minutes? Yeah? Okay, thanks. But, although the European Union has achieved much in the field of humanitarian aid, we also have to recognize that the Union is a zone of complexity. While it may aspire to many common values, the emphasis that its members place on those values, of course, differ. So can we really call it a consensus in its true form? Is there really a consensus on humanitarian aid, which is a strong normative concept? For example, the Voice study, the Voice is a coalition of NGOs, did a study in 2014 of humanitarian aid. And one of the conclusions of this study was that humanitarian aid isn't independent at all. The consensus talks about humanitarian aid being a value in itself. It's not linked to military intervention. It's not linked to security agendas. For example, if someone is suffering, I don't place conditions on alleviating their suffering. I don't say, well, look, you're suffering, but I'll help you if you do this, this, and this. It's a needs-based approach. I recognize their need and I give them humanitarian aid. I don't make it conditional. But what the Voice study found was there was a tendency in some places to conditionalize or make aid dependent on conditions linked to security, for example. Charlotte Day, in her article her working paper from 2014, adds also that the European Union tends to take a resilience-based approach to humanitarian aid. We will provide humanitarian aid, provided that you show resilience with regards to risk in the future. So can you show us that you'll take this aid and use it in such a way as to minimize risk or to develop yourself for the future? Again, that isn't consistent with a needs-based approach. If I see someone in need, I help them because of their needs. I don't conditionalize that support, but yet studies have found that the EU does. So I want to just end with a few comments. The EU is an area of values before law. Yes, so we have these values which are in the treaties and expressed through the various treaties, for example, Article 2 of the Lisbon Treaty, but those values aren't, of course, settled. Not all member states agree on them. What the European Union does for its institutions and procedures is provide a fora or mechanisms to discuss those values. And it goes back to the point I made earlier on today, looking backwards, not always forward. And this raises questions as to the efficacy or the use of the word consensus within the EU consensus on humanitarian aid. To say there is a consensus is probably a misappropriation of the term. To say there's an EU consensus on humanitarian aid doesn't quite stand literally. There isn't a consensus on humanitarian aid because humanitarian aid is as political as all the other decisions that are taken within a zone of complexity. The word consensus, humanitarian aid, solidarity, etc. are strong normative terms which suggest an accordance, a concord, a unanimity of a strong moral unanimity, which the EU by its very definition cannot have. So the question becomes vision and visionary. Is the EU humanitarian consensus on humanitarian aid, is it a vision or visionary? I would suggest to you that it's a vision. It lays out a particular view on how something should be done, but it's not quite visionary. It doesn't lay down a very loose, a very normative set of frameworks to aspire for a better future. It's a very constricted, very tight set of norms, not a consensus in any way, shape or form, certainly not a normative consensus. And we've seen this in terms of how the EU is approaching certain situations right now. For example, when it comes to the treatment of refugees, when it comes to Syria. My question would be this: if there is a consensus, an agreement on fundamental principles such as solidarity, suffering, humanitarian, and other values, then why do we see the rhetoric or the approach that we are seeing in certain quarters today? It's because it's not a normative consensus, it is a framework, and it's a complex framework which doesn't always accord with strong normative values. I'll leave it there. Thank you very much.
Thank you very much for a very interesting presentation and for some things that ought to be rethink. But now I see just the presentation, but now it's a time for Dr. Regina Valotita from Nicolas Ramirez University. So now the floor is yours.
Thank you very much for the presentation, and thank you very much, Parish, for the beginning of the discussion of what is a vision or a visionary policy of European Union. And I would like, as we started from one of the external relations policies, humanitarian aid, I would like to continue with the another important measure, which in a way also shows the face of the European Union in the eyes of international community. And I'm going to talk about sanctions or restrictive measures, as sanctions, as they are understood in a very classic way, are called in the Treaty of the Functioning of the European Union, namely in Article 215. And my question, the question that I am raising is, I'm just inviting to rethink the value of European Union restrictive measures, and do and when the values matter. When we talk about restrictive measures. Now, what are the main questions that I'm going to raise? So basically I'm going to raise 3 arguments and 3 questions. So well, unfortunately you cannot see everything in this presentation. I have no idea why, but first of all I would like to talk about about the development of the legal standards within the regime of the restrictive measures, because for years sanctions were associated basically with the political nature, meaning that the Security Council convenes and then they adopt certain measures on behalf of United Nations as an international organization. Or when it comes to, of course, the states also have the power to take sanctions as a policy measure. And then I would like to also discuss the second question, which is status quo. So defending values despite of the political nature of the procedure, of the adoption of the measures themselves. And basically I'm going to talk about the rights of the individuals. As at the moment, when it comes to European Union, we have a lot of targeted so-called sanctions, which means that they concern particular individuals and not the third countries. And of course, the protection of human rights come into play, and of course, the synergy between the values and the measures. So, is it possible, present, or only foreseeable? Talking about coming back to the question: is it a vision or a visionary? I hope you will see. It's clear. So, I would like to begin with the development of the legal standards and of course the first case and the first case law that comes to my mind is of course CADI case, and it was in 2008 only, when the European Court of Justice was asked to first of all decide whether we really care about the human rights in the sanctions or in restrictive measures, in particular when we talk about targeted measures. So the traditional approach that we had was that obligations under the United Nations Charter override other obligations. So if the United Nations Charter, if the United Nations Security Council take the measures, so that means that they override all other obligations of the states. So this was the traditional approach that was used for years, and there was not even the idea that we could come up with certain question of the protection of human rights within. Now, Lisbon Treaty made it possible to challenge the targeted measures or restrictive measures, and to challenge them before the European Court of Justice, and of course this only concerned the so-called targeted measures or individual sanctions. It was not a measure designed for the measures taken against the states as such. And CADI saga, which is we consider one of the most dramatic decisions of the European Court of Justice, as putting the distance between European Union law and international law, and you can find among the scientists also the saying that from this case, when we talk about the sanctions, international law sometimes is binding, which was not really what was accepted when we talked about the sanctions in a traditional way as the measures of the political of the policy only. And the CADI saga was important in the way that it was the first time when the European Court of Justice said that just have a look at the targeted measures as from the point of view of European Union law. So basically, the idea is that even if the European Union is implementing the sanctions or restrictive measures, so they have the precise list of the persons and they're just basically copying this to the European Union measure. So they have to respect the fundamental rights, because the fundamental rights is part of the principles of European Union and fundamental principles of the European Union, and this is part of constitutional order. So what is very interesting in this case that it was this decision, the General Court came up with a different idea, and they supported the idea that the European Union, any of the European Union courts, they have no possibility to review the sanctions of United Nations because they have they override the obligations. What they can only have a look is whether these sanctions would infringe Hogan's norms, which was a very weird approach, because in a way you say that you cannot have a look at the legality of the sanctions, but then you can check whether they do not infringe the Hogan's order. So, but this decision was annulled by the European Court of Justice, just analyzing this case as an appeal court, and we have, so from then on we have the doctrine that we have to care about the human rights. And basically the main human rights that we're talking here about would be the right to be here and the right to have a judicial protection. So, because in most of the cases what happened at the time, so the person was confronting only the decision that that the sanctions are adopted or restrictive measures are adopted against them without going into detail why and what are the evidences for this decision. And this was basically was challenging kind of cases, and the court said that this is what has to be done if we really care about the protection of human rights. For me, it is not really very important to go very deeply into these cases. I just would like to show what is the trend. And another case which was dealt in European Court of Human Rights was another case and versus Switzerland. And the interesting thing about this case that European Court of Human Rights was also confronted with the fact that European Court of Justice already took this approach, and they had to say what is their opinion, because this was considered to be the principal court taking care about the human rights. And interestingly enough, the European Court of Human Rights took the position that we believe that United Nations respect human rights, because they are not only take care of the international peace and security. The United Nations Charter has also the obligation to respect human rights as one of the principles of international law. So therefore, we believe that the United Nations Security Council also takes into account this obligation while adopting sanctions. And what the court said, so while evaluating the behavior of the state when it implements sanctions, we will have a look at the language of the Security Council decision to adopt sanctions. If it is clear from the language that the states are obliged to do something which is not in compliance with the human rights standards, so we will say that the state basically did not infringe the standards of European Convention of Human Rights. However, if the language is like not that clear and leaves some margin of appreciation to the state, then it will be the state's behavior that will be analyzed. So, and the interesting thing about NADA was that the person was restricted to enter and pass Switzerland, and the sanctions imperatively told that these restrictions have to be put on the persons. But the interesting thing was that Switzerland did not do anything in order to remove this requirement, or to remove this sanction to this person from the list, saying that this person was not the citizen of Switzerland. So this was why the court came to the conclusion that there was an infringement. And another case where the court clearly followed the same trend of analyzing what happened rather than taking United Nations Security Council sanctions for granted was Al-Dulimi case, and again the main issue, the core of the case was the access to judicial protection, and the assets of the person were freezed in 1990, and they were confiscated only in 2006. So for such a long period, the person did not have the access to judicial protection, and this did not seem to the court as in line with the European Convention of Human Rights. So we see certain alignment in policies of the Court of Justice of European Union and European Convention of Human Rights, and this is for me a good example how the practice of European Court of Justice, could have impact on other regimes. Even, interestingly here, on the regime of the fundamental rights protection. But for me, it's also interesting what is the future. And if you have a look at Z case, so, and this is the case which concerns the Great Britain, and I believe my colleague, Professor Kathrani, can even tell more details about the internal discussion. So what is the path? Where the European Court of Justice goes? So this was the case which concerned the Algerian citizen, which was also the citizen of France, and he had a wife who was the citizen of the United Kingdom, so they were in terms of European Union citizens. And upon return from Algeria, he was not allowed to enter to Great Britain due to security reasons, national security reasons. Now, he was not given an explanation. He was just asked the questions, and as the answers did not satisfy the institutions, so he was not allowed to enter Great Britain due to national security reasons. So, and of course, this case was brought to the European Court of Justice, and the question raised was, if you do not satisfy due process requirement, so meaning like if you do not allow the persons to get to know what the evidence is. So can you restrict the right to freedom, to free movement, and can you restrict, well, in a way also the right to due process? And the European Court of Justice here, it was very strict. So saying that you cannot, yes, we understand that the prevention of terrorism and fighting terrorism is a very important reason to restrict the human rights, but this means not only restriction, but simply denying of the due process rights. So, and of course, the Court of Justice of European Union did not accept that argument. And it's interesting. It's an interesting turn where the practice of European Court of Justice is going, and it seems that the standard is very high, no, towards the world. And this is the standard, of course, of the European Court of Justice as being the main institution analyzing, explaining the European Union law. However, let's go back from the point of view of individual now. So we have very high standard in terms of human rights, of the protection of human rights. Now let's have a look at the question when. So is it really, we have a high standard of protection, but how it is accessible? So let's start from national courts. So the person, if he goes, and we had a lot of examples, if he goes to the national court and is trying to challenge any of the decisions concerning restrictive measures or sanctions, so most probably, in particular, UN sanctions, so most probably he will fail. Why? Because any national court would say that we cannot challenge we cannot abolish or annul the UN sanctions because it's not us who adopt them. We do not have that kind of competence. So that means that the person would have to go to European Court of Human Rights or at least a national court, if it comes to the restrictive measure, would have the possibility to go for preliminary ruling, which means that it takes a lot of time. In any case, this is the access only to the international, let's say, judiciary, and then not everybody can do that. So is it effective? Most probably not. Now, when it comes to national court, is it possible to change this? National courts, they do not have information about the reasons why these persons were included into the list. They are not informed. They cannot get access to this information. So some of the scholars, they would say, well, it's mission impossible to change anything and bring this to the national level. And we have, of course, the actions for annulment under the Treaty of the Functioning of the European Union. But again, we come to the same question. Who can afford to go before the European Court of Justice? Not everyone, that's for sure. In particular, taking into account that you are not there, you are somewhere else. So you know, the question one, it's the answer is, well, not always, far from always. And which makes this right a bit more illusionary, although the standard is quite high. And then the question: what about the balance? What about the balance between what we are sending, the message we are sending to the world, that we really care about these standards? And this is basically the practice that is formulated by the court. It was not the initiative coming from the community. It was not the initiative coming from politicians, because their position was it's political question. It cannot be legal. And actually, even the General Court, when the General Court had to face another case concerning restrictive measures, which was CADI 2 case, it gave a dose of criticism to the European Court of Justice, who was deciding the case, CADI first case, as the court of the first instance. So it seems that in the eyes of the international community, we are having a very nice face, no? Because Europe is considered, wherever you go, Europe is considered as a cradle of human rights. Sometimes Europe is thought to be like a cradle of humanity. And I remember my experience in being in a very small island and saying, like, well, I'm European, and they would look at you like towards alien. You're from the other planet. Wow, it's Europe. Yeah, but so this is in a way this case law is very much in line with this vision. However, we come back to the question of what is the value of restriction measures if we have such a huge difficulty to agree on them. And even if we take the question of, for instance, Ukrainian situation, no, we hear so many talks, of course, by politicians that maybe we should stop applying restrictive measures towards Russia. Why? The situation hasn't changed. It hasn't changed. But there are some other issues, and in most of the cases, more economic and political. And wherever we come to the taking the decision, we have a fear that it may not continue, and we may not stand for the values that we say we have. And of course, the annulment of these restrictions can lead us to the infringement of other human rights, which I believe the Ukrainian situation exemplifies this very well. So is there a proper balance? Again, another aspect. The measures that we have within the European Union, it seems that the high standard towards other world is higher than to the measures of the European Union inside. So is it vision or visionary? In a way, we have a clear vision of the European Court of Justice. We have clear vision of the European Court of Human Rights. These courts managed to influence the whole situation in the United Nations, because we have now ombudsman, we have now focal point established. We have now the possibility, the individual has now the possibility to go directly and say something, which was not present before. But when it comes to implementation and really the power to take the decisions, we still are not sure whether we really want to stand for these values. So in terms, it seems to be more visionary. So this is how I would like to end my presentation, and of course invite for the discussions that will forward afterwards. Thank you.
Thank you very much. Of course, there is one other question. I mean, what does the European member states were doing in the Security Council? Yes, because the decision just violate human rights. So it's interesting, just a different approach on the state side and a different approach in the case of international organization. So now I would like to introduce Ms. Dr. Natalia Ćwiczyńska from the University of Poznań, Adam Mickiewicz University. So the floor is yours.
Thank you very much. Thank you very much for the invitation, and I'm very pleased to meet you all there. And I want to talk about unrecognized states and European Union. Why? European states are often called black holes. Unrecognized states are often called black holes. What unrecognized states? It's Transnistria, which is in international law is integrated part of the Republic of Moldova. Nagorno-Karabakh, which is the part of Azerbaijan, and South Ossetia and Abkhazia, which parts of Georgia. So these entities are part of Europe, which is generally perceived as an area of respect of human rights and area of rule of law. But citizens which lived in these entities live in another Europe. These entities are isolated, autocratic, and not well developed. As we well know, that respect for human rights and rule of law is one of the cornerstones of European Union external policy. And the main question is European Union is capable to bring its values to residents of these unrecognized states and to improve their quality of life? To speak about unrecognized states, we should remember that they all have common features, such as isolation from the international community due to their unrecognized status, and very often their perception is negative. They are perceived as territory, as a black hole, as an outlaw territory, as a base for organized crime and human trafficking and struggling. Very often, economic restrictions and political restrictions are applied by the international community. In such entities, foreigners rarely invest. Exception is the Transnistria, where there are a lot of Russian investments. And we should remember that citizens of such entities are able to travel abroad only if they have passports of any recognized state. For example, Transnistrians have to receive Russian passports or Ukrainian one. In Nagorno-Karabakh, residents apply for Armenian passports, and in South Ossetia and Abkhazia, it's Russian passports. And initially, the European Union engagement was focused only on humanitarian assistance. And only with the establishment of the European neighbourhood policy in 1933, European Union has deployed a number of foreign policy instruments aimed at conflict settlement in conflict areas. And there are European Union special representatives, for example, for the Republic of Moldova and for the South Caucasus. And the action plans which are signed with these states. And only from the 2009 we could speak that European Union have policy towards two unrecognized states and its engagement without recognition. And it's defined as an apolitical approach oriented primarily towards support of civil society in the fields of democracy and human rights in these entities, and they also confidence-building measures. These strategies especially targets Abkhazia and South Ossetia and omitting Nagorno-Karabakh and Transnistria. But actions of the European Union seem to prove that strategy could be extended also on those entities. The European Union can combine political, financial and technical instruments in an attempt to influence the situation in these entities. This includes humanitarian aid and limited support to the local civil society as well as confidence-building measures. And the first entity is Abkhazia. In this entity, the financial involvement of European Union is impressive. At the beginning, from 1992 till 1996, the help from the European Union was funded on humanitarian assistance. And every year, the European Commission approved humanitarian aid for Georgia, and part of this aid was dedicated to Abkhazia. And after 1997, European Union provides funds for rehabilitation programs in Abkhazia, and those projects aim at improving living conditions of the local populations and designed to assist in creating conditions for the return of displaced persons to this entity. It's very important that European Union became the biggest international donor supporting post-conflict rehabilitation in Abkhazia. After 2002, there are several financial instruments available for Abkhazia. It's the European Initiative for Democracy and Human Rights, Development and Cooperation Instrument, and the Instrument for Stability. And these instruments are aimed for confidence-building programs and for civil society development. And it's very important because due to these instruments, after the August war of 2008, EU-funded programs are still going on in Abkhazia. And the EU remains the largest donor in Abkhazia. Of course, support of the European Union for rehabilitation of this conflict was effective in easing some of the difficulties that people in the conflict faced, in the conflict region faced. But the biggest success of European Union assistance to Abkhazia was the investment in civil society development. In many respects, this help support NGOs and provide and resulted in that Abkhazia is potentially open to the broader cooperation with international community, because as we will see in the case of South Ossetia, initially the aid from the European Union was humanitarian assistance. But also after 1997, rehabilitation programs in South Ossetia were based on humanitarian assistance. The programs focused on cooperation with local NGOs were very rare. And there were 6 priority areas in Ossetia. It was road engineering, civil engineering, finances, banking, agriculture, and energy. And local NGOs were not supported by the European Union. And unfortunately, after the war of 2008, all projects of European Union consequently came to the end. And till this time, the only international organization which could reach South Ossetia is the International Red Cross. Another organization can't reach this entity. If we will see to Transnistria, this involvement of the EU in Transnistria is less significant in the Abkhaz case. Till 2002, the European Union avoided any involvement in Transnistria because the perception of Transnistria in European Union was that the Transnistrian conflict was the most peaceful conflict from the all conflicts in the former Soviet Union. Of course, if we will compare conflict in Transnistria with conflict in Nagorno-Karabakh, in Nagorno-Karabakh we have 10,000 skilled people. In Transnistria it was only 300. And so Europeans thought that it was the most peaceful context. And only in 2009, European Union started to finance projects in the Transnistria, mainly in the field of confidence-building measures. And objectives of this project is to support for civil society and the establishment of greater confidence in the relation between Chisinau, between the Republic of Moldavia, and between the Transnistria. And the European Union believe that they will be able to create a forum for discussion between people, residents from the both sides of the Dniester, and lead to dismantling of stereotypes. From this year, 2009, the European Union funding was extended to projects to Transnistria directly, and Transnistrian projects received 15% of all funds which go to the Republic of Moldova. The best situation with the European Union engagement is in Nagorno-Karabakh, because before 2010 there have been no financial assistance from the European Union provided for Nagorno-Karabakh. And till this day, this influence of European Union remains very limited. European Union has provided assistance for Azerbaijan till 1991, but never these funds can't go to Nagorno-Karabakh. The only project, and the first project and the only project of the European Union now in Nagorno-Karabakh is the European Partnership for the Peaceful Settlement of the Conflict over Nagorno-Karabakh. And objectives of this project are following: media initiatives, conflict-affected groups, and public policy. Also, we have to remember that in all this case, the intervention, the activity of the European Union has been subject to parent state approval. If in case of Moldova, government of Moldova is itself invited the European Union to involve in Transnistria, so in Georgia and in Azerbaijan, the European Union met many more obstacles for an effective involvement. And some officials there stated that they would prefer that the European Union would end its funding programs. And arises question, why? It can be explained that the that it's fair that European aid could lead to the consolidation of unrecognized institution and even to international recognition. Very often these states allow for European aid only if this assistance would not contribute to the consolidation of the separatist regime and would not lead to the establishment of official contact between authority of unrecognized states and international community. Very often we could hear that that European Union is criticized due to its policy or lack of its policy to unrecognized states. But in my opinion, even such activity which European Union have in such entities is very well, because as we see at the example of Abkhazia, the European Union funds were the reason why Abkhazia stay open for international involvement, because locals NGO insists on it. Local NGO which are not presented, for example, in South Ossetia. So, in my opinion, it's better than nothing. Thank you very much.
Thank you very much for the presentation, and now I open the field for the discussion. So, are there any questions?
Thank you very much. It's always difficult to intervene when you are between yourself and the lunch, so I'll try to be very short in my intervention. Because thank you very much for your papers, first of all. I got three questions which are somehow interconnected. The first one concerns this idea of values before law. While being in favor of such legal reasoning, I'm more doubtful when it has to be applied to the EU as such. So if it's part of a path toward something different than the EU as such today and probably tomorrow and after tomorrow, okay. So I mean, it cannot be applied in this. If we are building something more, then this issue is much more has much more sense than as it is now. The EU, which struggle between being an organization, a community of power, and something else. So that's my my question on this. So I'd like to know your opinion on this. On the interesting issues raised by Regina in your intervention, I think there is also another problem in when you raised all the question of the individual, how to protect individual from the possible abuse of his rights. Once again, there is one thing which is missing, that is the possibility for an international court to supervise EU acts. And once again, the issue of the EU accession to European Convention on Human Rights is comes out because for direct involvement of EU institution maybe could be useful to have. Then there is also another internal question which is raised constantly when the issue of sanctions is discussed, is the question of the EU competencies. So one thing, once again, you have this dual personality. One thing is how the EU is perceived as a guardian of human rights, when they speak of third states, and how different is the perception of the EU as guardian of human rights within the EU sometimes. Maybe when I was thinking, maybe the EU is considered as a guardian of human rights outside the EU, but not among the EU citizens. But then again, it's on the third intervention, which is somehow I perceived it also as a specific extension of what Paresh said. Dr. Chinchilskaya points out the issue of the EU. I only want to underline one thing. This is the peculiar case in which the EU, as an institution which acts through its own organs, and the Commission is one of them, is perfectly distinct from the EU as the union of 28 states. Because for all these cases that you've mentioned, one could refer to all the political activities of support of other international organizations. One example could be the support for the group of Minsk in the OSCE for the Nagorno-Karabakh, or the openness to other initiatives in Transnistria. But then, what is used is the tool of the European Commission, which is independent from the approbation by the 28 for programs for people. So, as you said, could be better than nothing, but it's also, I mean, a part of this search of the identity in this context. So I do agree that this is part of that humanitarian action of the organization, which has among its own values really the respect for the need of people. Thank you very much.
Do you want to answer? Or, no, as you want. Okay. Okay. First of all, I have a question for Paresh, which in part is linked to what Giancarlo said. Because, so you say in your presentation, values before the law. Well, I think that we have to consider that this term of art, value, is used by EU treaties as a synonym of principles, and when we speak of principles, we are speaking of sources of law. So, my personal opinion, I think that the real problem is what is meant by principles of the European Union. This is my first question. The second question is for Regina, because, sometimes this Cadi saga is regarded by the legal doctrine, by legal writers, just as a manifestation, as a case of violation of the supremacy of international law. This is true. We have, on the one hand, the principle of supremacy of international law, and on the other hand, we have European fundamental principles. More generally, this Cadi saga is just the effect of the well-known counter limits doctrine, so the doctrine according to which it is possible to limit the infiltration of international law within national legal systems as well as within the European Union legal order in order to protect fundamental rights. We had a similar problem in Italy because there was a problem we had to implement to give execution to a judgment of the International Court of Justice, and this doctrine, so the counter-limit doctrine, was relied on to this effect. Now, the question is the following one. I don't think that the Cadi saga is a case of violation of international law. So, in other words, I think that when the European Court of Justice, when national constitutional courts like the Italian Constitutional Court try to justify in a very precise manner why in some cases one is obliged to violate, to disrespect international law. This is, in my personal opinion, a confirmation of the ongoing existence of the supremacy of international law, and I would say of the consequent need for the European Court of Justice as well as for national courts to disregard this principle only if strictly necessary. So, in my personal opinion, there is some cases where there exists a reasonable resistance to the supremacy of international law. And so I think we have to establish the conditions, the presence of which is necessary in order to regard this resistance as reasonable. That's the real problem. So it's not a problem of, in my personal opinion, of violation of international law. We have to establish when this is possible and which conditions must exist in order to violate, in order to, more or less, in order to resist to the supremacy of international law. Thank you very much.
Thank you very much for both of your questions, which I think are quite similar. So I'll just, if you wish, deal with them both together. I strongly subscribe to, and I believe in the notion of value before law. I think that it's something which is natural. In our own lives, before we choose to do anything, before we act from an attitude. We act from our philosophy, we act from our upbringing, we start from a certain starting point of who we are as characters. Whether we choose to give expression to that, whether we agree to acknowledge that or not, we cannot doubt that everything that we do starts from a conscious or subconscious attitude. So this notion of values before law is something which is inherent within us, whether we choose to articulate it or not. And that applies both on an individual basis or on a collective basis. Every action is always preceded by an attitude. Now, if I take that one step further and I then articulate that as the notion of values before law, what I'm trying to get at is that one can have two interpretations of a value. One can say a value is we take it consequentially. We say that we define values according to whether they're good, how good they are, a consequentialist approach. So that when I am seeking to enforce those values, I say that what I deem to be valuable is what gives me the best return or best consequence. Or one can say, no, I define values simply by being good, by having a goodwill, a deontological, a Kantian approach. So we say that my approach to value will be not what will be the best consequence or best outcome for me, but what my approach to value will be, I'm going to do what I deem to be good, and what I think is good is have a goodwill. And I think that often there's a tendency, often in our personal life when we're dealing with people, but also at organizational levels, to take a very consequentialist approach to values. What I deem to be good is, will it give me this, will it give me that, will I get that much back in return, or will I get this in our transactions with people, and we forget about the goodwill. Now, so what I would counsel, what I would say is that, and it's a very idealistic thing, is that whether individually or as an organization, one needs to acknowledge that we need to start from a moral foundation, a starting point of a goodwill. And certainly that was the genesis or beginning of the EU as an organization. We need to avoid what happened during the Second World War. We cannot let that happen. What happened was bad. We need to act good. So there was a strong deontological response to what happened during the Second World War. But I think what has happened over the years is that things like realism, politics, power, self-interest has clouded that. And what I'm counseling is, well, look, no, stop. Take a step back and look at the goodwill. Otherwise, words like solidarity, words like human dignity, words like commonality, all of these are just lip service. They have no substantive or moral content. it would be better if we didn't use those words. If one wants to use words like solidarity, good spirit, goodwill, good dignity, expression, commonality, those are normative concepts. If you want to use them with the will that with the goodwill, as opposed to instrumentalizing them. So just to basically say, yeah, values before law, but I endorse a deontological approach where it says start with a goodwill, a good attitude, as opposed to a consequentialist. And one last thing I'll say is that goes back to the point I made earlier, truth and reconciliation. One way in which to start with a goodwill, a good attitude, is to talk to someone and say that, look, I understand what your point, my point, have a truth and reconciliation. I don't think the European states ever had that back in the 1950s. I think there wasn't truth and reconciliation. I thought, okay, sweep it under the carpet, we'll identify common goals to move forward, but what they haven't done is resolve their differences. So that's what's instrumentalized or consequentialized values, as opposed to starting from a common platform of a goodwill.
Thank you very much for very good points, and actually it's not enough. I could talk about that for I don't know, for the whole time of the conference, but there were brilliant points that were raised, and in most of the cases I fully subscribe to your opinion on the points raised. So first of all, the question of European Convention of Human Rights and European Court of Human Rights. I don't want to go into the detail of this aspect, because we will have another presentation of the compliance of these systems and whether it's possible and to where it leads. But we already had one case when the restrictive measures were indirectly challenged. Which is Bosphorus case, and what is interesting, what is the difference, let's say, in when it comes to UN sanctions, was that the European Court of Human Rights accepted the equivalent protection. I mean, it accepted that European Union gives an equivalent protection, and what the court went on to say that we're going to look at the content only if there are particular circumstances, gave the standard of when. And when in case of United Nations sanctions, the European Court of Human Rights did not accept that the standard, that the protection is equivalent. So even with this, even if there is a situation in the European Union in the end agrees to, finds the compromise to exceed the European Convention of Human Rights, I think that in that sense the practice will not change. But just generalizing the idea of the place of European Court of Human Rights in this case. When it comes to the different competences, and of course the point that European Union, the human rights are not protected at that extent internally in comparison to the external standards, if I understand that correctly, I fully subscribe. And even if we take the same components like terrorism and human rights, lately, I see numerous measures of mass surveillance taking as measures at the European Union level, and what is very interesting, they target the community, people generally. All the people, I can mention a lot of them, starting from PNR, which was very much the debated passenger name record. So, and what is the Telecommunication Directive, which was abolished? So a lot of measures that target the whole society and not those whom we are afraid of. And when it comes to sanctions, these are those whom we protect. So it's the contrary situation. And this is what is not acceptable to me personally, and I believe that the standard of human rights protection, unfortunately, but it's a bit different. And it seems, at least, even if on paper we say that it's the same, in practice I do not see that to be different. And what is interesting, these initiatives are pushed so much by the politician, taking very, very subtle events or very tragic events as the driving force of these mechanisms, and these instruments, they do not go to the European Court of Justice just because there is no will to do that. I mean, there are no 14,000 citizens, as in case of telecommunication directive, who would go before the court and would say, stop it. So this is the idea. I fully subscribe to you. At least this is what I see now, what is going on in Europe. And when it comes to supremacy of international law, the point that was raised, the last point that was raised. Well, in principle, I wouldn't like to get into the details of the relations between the supremacy of international law and the position of the state as the actor in international arena. But when it comes to European Union, which was my focus, in principle, from the analysis of the provisions of primary law, I do not find any strict obligation for European Union to implement United Nations sanctions. I do not find any strictly defined obligation why European Union, as international subject, has to automatically put the restrictive measures. Yeah, but a United Nations Charter does not apply to international organizations. So this is the idea. It's only the member states of United Nations who has the obligation under the Charter. And what you can clearly, but this is my personal approach, what you can clearly see at the primary law, that European Union respects the UN Charter. Okay. You can respect, but that does not mean that you, by taking automatically replacing what was adopted at the level of the United Nations, you infringe your fundamental values. So for me, this is where European Union could simply stop and say, well, let's have a look whether we should do that. I think that these measures, when it comes to restrictive measures, is just like more comfortable form of implementing UN sanctions. Just like you don't like to have separate member states taking different decisions, you just do that at the European Union level. But this is my personal perspective after analyzing even the protocol.
Also, if you read the current judgment, in a way, so I get the impression that the assumption is that international law is binding.
Exactly.
That's the problem, yeah. So this is, I don't know, thought to justify violation of international law. I mean, it's very symptomatic of the ongoing of the existence of the supremacy of international law for the European Union as well. But in my opinion, of course, yeah. So I get this impression, yeah.
But I think I see the tendency, let's say the same tendency in the constitutional court and the European Court of Justice. No, the same. Okay, yes, we respect. But when it comes to fundamental values, this is the constitution that matters. And at least this is we have in Lithuania. That this is what you can notion and can feel in other constitutional courts. So the same in European Court of Justice. So yes, of course, we are members of international community, but this is the fundamental the constitutional norms that matters for us. And you can, looking from the point of view of international law, that's a crazy situation in terms that you have to really, if you take that for granted, if you just adopt it, you have to rethink international law. So, and this is what international community has started doing in terms, for instance, they revised the articles on the responsibility of international organizations, now taking into account the specific features of European Union. So I don't know how far it could lead, and this is the big question of I think that has to be put at the table. So. But thank you. It was a brilliant issue that was raised, and that's really the big headache, I believe, for international community as such.
Thank you very much for this remark. I'm fully agreed with you, and you are right. It's those projects of our European Commission almost, but we have to remember one thing, that in perception of residents of unrecognized states, every project, every instrument in this unrecognized state is from European Union. For example, when in 2013 was extended the mandate of the European Union Special Representative for Moldova, the Transnistrians asked, why the European Union left us? So their perception is that the European Union is as a whole, as European Union, but I fully agree with you, and you're right. Thank you.
Now is my time. Now I would like to thank you very much for the presentation, which were brilliant and very interesting. And also, Regina mentioned that we can just organize another conferences on this this aspect of relations between and about the values and principles, about this what is important relations between European, even not only European but regional law as such and international law. So thank you very much for the presentation. Thank you very much for the discussion. And I think that I will just follow organizers, and I can say that we ought to have a lunch. Thank you very much.
I believe it's...
I'll do that. Okay, so the lunch is actually 1 floor above us.
Which is another issue connected also to UN sanctions, and but could raise also some discrimination problem or which would touch another principle of the EU to act without discrimination.
When it comes to UN sanctions, it's like a big form of discrimination always.
It is true also that from the Strasbourg court they always try to the cases where the cases of Kosovo, in which they say, well, we say that they obey the law. Which one?
That's a good one. Which one? No, you're not doing that.
We're going to discover whether we have
třeba nepozval vůbec.
Ale ty už tam jako na tom mluvíš.
Ale tam byla třeba i paní Merenová, kterou pozvala paní Jendra, takže ono to není zase tak.
Je to tak divný.
Ano. Já jsem tam byl jako... Je obvyklé, jak si všichni něco tady většinou. Jaký poslal si sehnal nějaký ty, protože zbytek na e-mail, který mi nezabil hlavě práce.
Já se schválně zeptám tam, jak
tak jsem mu řekl, že já myslím, že mu to možná to ale jako ten někdo, který si nechával všechny data, takže e-mail.
Já ale mám třeba ty údaty vůbec nestará,
Ale
někde tady někde bylo, třeba i ne.
Já jsem mu udělal všechno, jako hodně štěstí a aspoň dá se to tady. Tím jak může dělat.
A musíte se rozhodnout. Co je jestli si pracovala mezi Yes, já jsem plavat. A už se to jedno, protože to máme všechno vejček. Tak mám se podepsat i vejčka. Tak vidíte, můžu napsat do práce, že nemůžu přijít. Že máš tady. Jo. Já jsem tam teď, až to mám
ještě trošku mohu zaplat.
core systems belongs to the summer semester. To je... Co říkal pan Kohout? Na co? To, co s tím budeme dělat?
Jako mentálně, nemyslím, že bych osobně, ale jako to samozřejmě není. Je taky možnost.
Tak můžu dát trošku vrátníku tam?
Určitě.
Jestli to nevadí.
Jo, určitě. Můžeme to i dát na tady.
Já to dám takhle, a mi to pak vrátí.
No, jasný.
No, přesně. Tak když nebude něco, tak řekněte panu, že jsem to a kdyby to nějak vadilo, tak se omlouvám.
Vůbec, myslím si, že to je problém. A jestli vám mám takhle
já mám tady zatím mám jsou nejlepší. Já tady mám, když tak to, já tam jo,
take more if you want. Mluvit česky. Vem si víc, jestli
ono totiž za chvíli přijdou chlebíčky totiž.
no,
Každý jako hodně chlebíčků přijede.
jo, no, to přijde, že to není potřeba, ale
Jako, ano. Jak říkám, fakt hodně, jo, přijede.
no, to vydá 30 no, jasně, no, tak...
Takže se pak omlouvám.
No to vůbec se neomlouvejte, to je samozřejmě, jak si to objednali, tak to mají, jo? Jo.
Jo, takže skleniček je tady dost, to vůbec moc nebudu, kafe taky, kafe vyměním pouze, tady je hodně. Ne, pokaz to je, a co mi jenom to tam už to jsou v té hlavě.
Aspetta, lo so. Dovrebbe essere qui, visto prima. Sì.
Qua?
No.
Ok.
Che già hai fatto, Vicky? Chiedo
Aspetta, ma poi... E poi...
C'è il mouse sotto. C'è anche il mouse,
Dove?
Sotto ci sta il mouse. Oh, se lo sono mangiati. Dove sta sto mouse? Scusa. Sì, sì. Dove sta il mouse?
I hate the touchpad.
Vabbè, eccolo qua.
E tra l'altro non si vede bene in effetti, non si può.
Un po' solo così, poco all'indietro.
Allora, io faccio una cosa. Prima mi carico, perché devo anche...
Poco così, oppure questo. Così si vede, se no non si vede. Allora, aspetta. Transcendent. That is the name I've... Let's see if it's working. It's not working. Hello. Wait. Sabina?
Scusi, ma dove sta il tuo posto? Dov'è?
Transcendent.
Non si apre.
Yes, okay. You need to push the this. That's open. Yes. Which file?
Mind to be, yes. Prague. Yes. So we can already. I'm the first or what?
Sorry.
I'm the first, I think. No?
First on the program. I think so. Yes.
Oh, so we can already.
I don't know if Professor Ranchik is going to say something, but
even if he talks, I will not have it.
And if you want to make it bigger, just press F5.
And then what is the thing?
That's there.
Even if I would put anyway my computer there, because there are some little things that are, it's not easy. It's very wow. And if I speak like this, they don't hear me.
Yeah, we do. No?
But I would like to put my computer there.
Okay. I can make it a little bit down.
And do you think I can find somewhere an espresso?
Tu lasci il
Because
pendrive,
I don't like normal coffee.
Sure. There is a coffee break. I can get it for you if you want.
Yes, are you sure?
Yeah, of course.
Is that a problem for you?
No.
I don't think so. Wait.
I think it's about.
Yes, this is.
Yes, just stick it to one of the appropriate holes. Yes. There, I think.
Quindi cancello tutto, spiace. Quindi cancello tutto.
Hey.
Hey. It's not easy. The
Not
touchpad
easy.
is something I hate. There's no mouse?
This could be, I think, somehow. Yes.
Ecco qua. Corset. It's my.
Bravo. Sì, bravo. But then I don't need that anymore afterwards.
No, not yet.
Okay.
You know. Yes. Yes. If you want to remove it, say yes. I don't do that. But I understand.
You brought something? What? No, I didn't broke anything. No, not yet. I know it could be my style, but in this, I hope they're not. Are we? What is the subject? It's about infringement values. When what happens when it's very much about Hungary. Should we sanction Hungary for infringement? It's very not politically correct. As I like, especially here with Visegrad group. Isn't it the right place to talk about this?
Oh, okay. Good.
We go
This in
Polish?
Czech Republic.
Perfect, huh?
No, enough.
Thank you very much.
I like
And the first word is pronounced wow.
Whoa, yes, me too.
Wow,
I
to the value
went
through
to,
which the
to
occasion comment.
Google and said, how do we present whoa? Because it's from French, from the French, I put it there. It's from the French movie, the French translation of the movie. We call it's the French translation of the title in English. Home from the Hill. So for French, it would be very clear. Celui par qui le scandale arrive is just only three. Let's say I studied German and I studied Arabic, but I don't remember anything. So. Allez, un petit effort.
In Italian, I can speak only one sentence.
Which is?
Viaggetto a bene.
And why this? I hope they are not filming us.
They are. It's still streaming. Yeah, I don't know how to turn it off, so it's permanently on. Just the microphones are off, I guess.
Oh, you can see me gesticulating. Perfect. It's too tall, I feel like I can't do
Yeah, so I mean, he's very smart. Of course, he's not fully part of the system here because he's American and I don't think he has any intentions to get habilitations and so on. But he's keep on participating in conferences. And I guess
No.
Thank you. Change back, and I don't know.
No, nothing.
You don't need.
Absolutely nothing. No sugar, no. But so here, no, I should do.
If you want to go forward, just press this. No, well, it doesn't work because, wait a minute.
Or this one.
There is a menu, so we need to get.
have to wait for the marine.
Busiest chairperson, having more speakers than the other chairpersons.
Yes, because it's 4.
I think so, yeah.
3, because Marine, where are you? We are waiting for you. Yes. And we are late because of you. Anyway, should we start? Okay, ladies and gentlemen, I think we could start the third plenary session. Thank you for the organizers that I could be a president for this plenary session. It is entitled Human Rights, a Soul on Paper or in Action. And the first speech will be Professor Marine Toulier from Rouen University in France. Woe to the hexagon of value through which the occasion cometh.
Thank you very much. I gave you a little explanation of the title. It's a French translation of the book, Reimagining.
It's, yes.
Probably better, yes. So the explanation of the title is the French translation of the movie Home from the Hill, and it's celui par qui le scandale arrive. A little bit of teasing is not bad, no? So, but I put a little more serious subtitle, just in case you don't like my kind of humor. Is the European Union a community based on effectively on common values? Notice the question mark. So as the subject is very broad, I will be addressing only the question of the recent mention of the values in the European construction history. Is it a source of disintegration of the EU or a factor of cohesion within member states? And to start with the very politically incorrect start, the recent call from the Luxembourg Minister of Foreign Affairs, Jean Hasselborn, to exclude, at least temporarily, Hungary from the EU for violation of its fundamental democratic values, according to me, it raised question, at least this, perhaps others. Is it a proof of the importance of the respect for the values in the cohesion of member states, as he pretends? Or, on the contrary, it could set a real and dangerous breach in the union of states, shattering the rest of the European unity? The answer which will be given to it seem to me, whoever it is, to be fundamental for the future of the European Union. The structure of my speech will be very easy, very short. It's two-part, and it will be just values. You've said values, and what values? Let's start with the first. Values, you said? So already the reluctance of member states to join the will of the use of the mechanism of the political penalties against Hungary emerge. And my question is that reluctance, is it a sign that the values are not really common? Or is it a sign that the well-known, yes, a sign of the well-known syndrome in international law of the cowardice of the state to punish another member state by the fear of the future reprisals? Or another possibility is penalties would be counterproductive in that they would increase the EU citizen both rejection of what the European Union means, the temptation to retreat into national self-interest, populist and xenophobic policies. Certainly the respect of the values are an essential condition of acceding countries to the European Union. But what happens when a state that has already adhered to the European Union is violating these famous values? Because in that case, the European Commission has lost his power to exercise a cross-compliance on this state. And it is because about the danger of the values and the principle and the fundamental rights, they may be put in danger within the European Union, not outside, that the European constituents consider mechanism of defense to ensure the respect of that values. The problem is, do we have, we mentioned it already, do we have the political consensus, the political will to use them? But first, let's see what are these tools I mentioned. So in March 2014, the European Commission adopted a framework to safeguard the rule of law in the European Union. So this new framework is for addressing systemic and not only individual violation, so systemic threats to the rule of law. Rule of law, just to remind, is the keystone of any modern constitutional democracy and one of the founding principles resulting from the constitutional tradition, common tradition, to all member states. And as such, one of the first values on which the European Union is based. And this, of course, infringement in one of any of the 28th member till now, 27 in the future. What is the purpose of that framework? The purpose is to enable the Commission to find a solution with the member state concerned in order to prevent the emerging of systemic threat, we mentioned, that could develop into a clear risk of serious breach, which is a step forward, which potentially trigger the use of Article 7 of the Treaty of EU. So the Commission can launch the so-called pre-Article 7, so we are before, by initiating a dialogue with the member state. The process has 3 stages. The first, the Commission assessment, is called the Commission assessment. So what happened? The Commission will collect and examine the relevant information, and if there are clear indication of systemic threats to the rule of law, the Commission will initiate that famous dialogue with the member state concerned by sending, so this is the first step, the rule of law opinion, which will be a warning to the member state that will have the possibility then to respond to that opinion. Then we have the second, sorry, I touched the wrong, I put it in the wrong way. Anyway, this is the first. The second is called the Commission recommendation. In this second stage, unless the matter has already been satisfactorily solved, the Commission will issue a rule of law recommendation this time, addressed to the member state, and it will recommend that the member state should solve the problem identified in the previous step. And the Commission will make public its recommendation. Then, if there's no solution, there will be the third step, the third stage, which is the follow-up of the Commission recommendation. The Commission here will monitor the follow-up, and if there's no satisfactory follow-up within the time limit that is given by the Commission, then the Commission can use the mechanism of Article 7. And the Commission will keep the Parliament and the Council regularly and closely informed of that continuous dialogue with the member state concerned. So that is the theory. Sorry, too quick. In the practice, what happened? Since 2009, the Commission was confronted several times with critical situation in certain countries of the EU, which brought to light particular problem linked to the rule of law. In response, the Commission has applied political pressure and launched infringement proceedings in case of violation of the European law. However, the mechanism of prevention and infringement planned by Article 7 was never used till now. Even if Romano Prodi, when he was the president of the Commission, said that said 2 things in a long speech, but I took 2 elements. When a member state is in difficulty, so is the whole Union. A supranational institution should not isolate an EU member, but keep it firmly in the fold. And the second idea, that thing is very interesting, is the Commission will not tolerate even the slightest infringement to the rights of individuals or any minority. My question is, I didn't put the question, okay, so my question is there a disjunction between the asserted will and the possible further action? I will not answer, of course. The EU imposed penalties on one of the member states only once since its creation. It was in 2000 against Austria. Remember the entrance of the right-wing, the extreme right-wing party, the Austrian Party of Freedom, managed by Jörg Haider, within the government, so 14 countries out of 15, because we were 15 at that time, had reacted by interrupting the bilateral relation, so limiting the power of the ambassadors, by also refusing to support its candidates for position inside the EU and also outside in the other international organization. If France, Germany and Belgium had led a campaign in favor of this ostracization of Vienna, Italy and Denmark had pressed for the removal of these measures. Then the sanctions were lifted 7 months after when Jörg Haider resigned as a leader of the party, although the far right was always a governing party. Why? Because 3 wise persons submitted to the European Union had concluded that Austria respected the European values, that retaliatory measures risk to have quite the opposite effect by increasing the nationalist feeling, and that consequently it was necessary to lift them. My question was, had this sanction the expected impact? They seem, in that experience with Austria, they seem to have had only not much real effect. So in the light of that experience, difficult question that we have to solve, not we personally, but the European Union, is it necessary to sanction Hungary or not? So first, Hungary could be sanctioned on 2 different fronts, according to my study. First, the refusal to apply the European solution to the so-called crisis of the migrants. By the way, the possibility, not very probable according to me, to deprive from structural funds the recalcitrant countries to the EU policy of quotas of refugees. Hungary can count on the solidarity, I think, of the countries belonging to the Visegrad group, which includes, as you know here perfectly, Hungary, Poland, Czech Republic and Slovakia, which are reluctant to apply the refugee quota. And so it's very improbable that they would vote in favor of penalties. But the German Chancellor herself, Angela Merkel, in September 2015, has rejected that possibility of reducing structural fund. She said, in the middle of a long speech, she said, threats are not the way to come to an agreement. It could have surprised a little bit this position, but I tried to understand why she said that so. And my idea is there are 3 elements. The first is that those countries I mentioned in the Visegrad are business partners of Germany, and we know that German industrial producers need to export. The second reason, it could be that there is a risk of weakening the Eurozone, which could be dangerous. And finally, another political end, the risk of rise again of violent anti-German feeling in these countries inherited from the period of Iron Curtain. So this is probably why. Could be other reasons too. But. So this is the first front of potential sanctions, let's say. The second, Hungary can also be blamed for violation of human rights, lack of abstaining from interfering with justice, constitutional reform implying the weakening of the constitutional court for the benefit of the executive power, and thirdly, the increase of intervention of the executive power, both in economy and in freedom of communication. So, if no solution is found in the famous framework I mentioned before, the Article 7 remains the last recourse, of course for Hungary, but for any other country, introduced so by the Treaty of Amsterdam after the crisis with Austria. How it works? The procedure, this is very long, but we will just see that there are 3 stages there too in Article 7. How it works. First stage, 3 likely sources of proposal of observation. Observation of what? That there is a clear risk of serious breach by a member state of the values referred in Article 2 that we already mentioned and we'll see later. 1/3 of the member states, European Parliament and European Commission. The term risk here indicates that it is a prevention tool. Then the second stage, the European Council, this time acting by unanimity, so we already know that it's not improbable but almost impossible, may determine the existence of a serious and persistent breach of member state of the values referred in Article 2. Third stage, the Council, acting by a qualified majority, so easier to reach, may decide to suspend certain of the rights of the member state in question, including voting rights, which is the maximum sanction we can imagine, of the representatives of that government in the Council. This time it is a sanction mechanism, clearly. A remark, there is no possibility to exclude Hungary anywhere. As you can see, there's no possibility. So what is called by Luxembourg's minister is not possible, but deprived of the right, yes, but not to exclude Hungary. Other possible legal resource is the infringement proceeding in case of violation of community law, famous recours en manquement. I don't remember how it is called in English, but it's article, we will not deal with, it's very technical, but this article of the TFEU, this is French, articles. This possibility, this solution is possible only if the court is seized. So, first condition. But the advantage would be the possibility to sanction Hungary on financial aspect, which is always, according to me, the most delicate but the most efficient sanction. But this modus operandi is considered little effective to avoid authoritarian drift of such a government. What my personal comment here is we are far from the liability diagnosed by the Secretary General Ban Ki-moon. I don't know if you know that speech in May 2010 in Kampala, Uganda, said that we left the impunity and now we are going to we are in the liability. I'm not sure it's still true, but. In this, if the EU doesn't sanction anybody, any state, it would mark that it is respecting the international law tradition. What we can see is that Jean Hasselborn always said the same, regretted that in the German daily paper Die Welt, the famous interview, people such as Viktor Orban, led the EU to give the image of a union which outside dares to defend values, which is not capable of anymore of maintaining inside, which is an interesting question, outside the image that we give and inside. So the second, it would be quicker, shorter, but what values? So I'm making research and to see where the word values was used the first time. So I had to eliminate Robert Schumann's speech, Treaty of Colin-Steele, Paris, 1951. I had to eliminate Treaty of Rome, 1957. No, not even in a single European Act, 1986, no values at all. The word is not pronounced. So if the project since the beginning had the political union as a name, the word values is not used. What I think it's a sign of the inversion of the international modus operandi in general, which is to start from a global project and come to concrete steps. Here it's just the inversion. It's only so the Treaty of Maastricht that appears the famous notion of values, and it is safeguards of common values. This word values is used in plural. And it's to determine the common foreign security policy, which is interesting also to note. It seems that it's while defining itself with regard to the third countries that member state had felt the need to proclaim the safeguard of the common values as a goal for the policy. The word taken from the Treaty of Amsterdam, then in Treaty of Nice, the term values is reused, but this time without the adjective common, disappears. It cannot be an omission, a mistake. It has a purpose, I suppose. So it enters with a small door. The term values enter with a small door in the text. The major change happens with the Treaty of Lisbon. In the preamble, the writers indicate as source of inspiration the cultural, the cultural, religious and humanist inheritance of Europe. These sources gave birth to value qualified of universal. No, it's not here. Sorry, I missed it. Universal. So it's clearly linked to the universalist conception, tradition, and not the relativist conception. It could be also suggesting that they gave birth to universalist thought. And the writer of the Treaty of Lisbon, specifying the content of these values, inviolable and inalienable rights of the human person, freedom, democracy, equality, and the rule of law. But the text is going farther the idea is going farther in Article 2. Sorry. There's something wrong here. Okay. It's the end. It shouldn't be, but I don't know what happened. Anyway, so Article 2, we already mentioned it. I'm sorry, you should have the text, but it's going further. The Article 2 defines them the human dignity, freedom, democracy, equality, rule of law, respect for human rights, including the right of person belonging to minorities. This time we are going to meet again the word common that disappeared before. It's a pity you don't have it, but anyway, Article 3 of the Treaty of EU asserted that the promotion of values constitute the purpose of the Union. And also this Article 3 took the opportunity to remind that in its relation with the wider world, the Union shall uphold and promote its value and interest, its value. Without a text, it's not easy. Finally, the last stage, and doubtless the most significant from the beginning of the history of the European construction, is the Charter, the famous Charter, European Charter of Fundamental Rights, based on common values and peaceful future. Are we sure we can't? It was just on strike. It's French technology. The Charter, no. This is Article 3. The Charter, based on common values for a peaceful future between the peoples of Europe, and for the first time it's not state, but it's people of Europe that is mentioned. What is interesting is that the preambles seem to derive from the conscious of its spiritual and moral heritage, the foundation of the Union to ensure the indivisible universal values of human dignity, freedom, equality, and solidarity. It is based on the principle of democracy and rule of law. And it places the person at the heart of its action, which was absolutely not the case at the beginning, of course, establishing the citizenship we mentioned today. Always in the preamble, the Charter indicates that the role of the Union is to balance these common values on one part, and on the other part, the diversity of the culture and traditions of the people of Europe, as well as the national identities we mentioned before. So the role is to balance. Just one word about the structure of the Charter. It is very original, because instead of using the traditional classification between civil, political rights and economical and social rights, it's a classification according to object. In other words, the principles. And we have only 6 values in the EU, which is very few, for such a program. So these are the 6 values: dignity, freedoms, equality, solidarity, citizenship, and justice. The only 6 values that we are supposed to have. And then the structure of the Charter is very original. Takes the value. Okay, there's this major title, and then we have articles, and article first is giving the definition. We can say human dignity is inviolable, it must be respected and protected, and then we have the rights that are taken from the dignity. So this is just an example, but it's the same, of course, of all these others. And you can notice that freedom is used in plural. It's not the freedom, but it's freedoms, which is also something interesting. Something more, but I would one more about the sorry. No, this is not. Just about the guarantee, there are a special group for the Charter, which is Great Britain, Poland, and Czech Republic, that agreed guarantees to the Charter of Fundamental Rights. So to the extent of that provision of the Charter, to the extent that a provision of the Charter refers to national laws and practices, it shall only apply in the countries mentioned only to the extent that the rights or principles that it contains are recognized in the law and practice national. So these are the 3 specific countries. So in conclusion, it seems that there are 2 directions for the use of values since the Treaty of Lisbon. Inward, the base on which the European construction decided a posteriori, because it was not in the treaty at the beginning, to raise itself, so it's construction, and towards the outside in its relation with third countries. And again, we seem to have 2 different categories from third states, the countries of neighborhood and the others. And for the first one, it is a question of establishing a space of prosperity and good neighborhood. And this space must be based on values of the Union. Okay? And as for its relation with the second group, the Union does not have to lose its identity and its new ethical spine represented by the value. And the Treaty of Lisbon insists on the defense of the value by the Union in the relation with third countries, Article 8. So in the middle of a very difficult period, it is not the first. The construction, the historical construction of Europe is always up and down, so it's not the first time, and probably not the last. But it seems to be true that it's through values that the scandal continually threatens to break out. Thank you.
Thank you. Thank you very much for the first speech. And now we'll be hearing Professor Fulvio Palombino from the University of Naples, Federico II, Italy. and the speech is entitled "The Rule of Law as a Principle of the EU, a Concept in Search of its Definition."
Okay, just a moment. Sorry.
This is the most difficult
Yeah.
fragment of the of the whole conference.
Yeah. Okay. That's okay. So thank you very much, Michael. And well, just two words to say that this conference proves once again how successful the project headed by our Regina, who is not here, continues to be. As already announced, over the next 20 minutes, I will deal with the rule of law at the European Union level. Well, that the European rule of law exists is commonly argued by legal writers, but the question remains as to whether this term of art may be clearly defined. The scope of my presentation is to answer the question and in particular to investigate it both from a theoretical and practical angle. As is well known, a clear trend exists inside and outside Europe of using the terms legal state and rule of law in a quite controversial and ambiguous way. This terminological difference indeed is not accidental and refers to two political and legal traditions which significantly differ from each other. The German experience of the second half of the 19th century and that rooted in the political and constitutional history of Great Britain. Accordingly, the question arises as to whether the two notions here debated may be compounded into a single shared notion of the rule of law, at least in terms of reference values. The German concept of Rechtsstaat, very quickly, mainly developed in the aftermath of the restoration which followed the 1848 revolts and was conceived as both a response to the absolute state and a reworking of the classical liberal thought and the principle behind it, namely the public protection of fundamental rights and the separation of powers. These two principles in particular resulted into additional axioms. The first one relates to the theory of subjective public rights and rests on the circumstance that sovereignty, as well as the power to establish individual rights and ensure their protection, belongs to the parliament only. The second axiom is reflected in the principle of legality, the so-called Gesetzmäßigkeit, whereby the executive and the judiciary are required to rigorously comply with the acts of the parliament, and this as a legitimacy condition of their acts. The English variant of the rule of law is different from the German legal state since it shares the idea according to which sovereignty belongs to the parliament but claims the normative supremacy of the parliament over the executive alone, given the common law countries' features, and in particular the absence of a written constitution. Courts are the main parties entrusted with the normative function and the protection of individual rights. This is also the reason why, according to a widespread opinion, the difference between the German and the Anglo-American doctrine of rule of law would lie in the fact that where the German one is contained in the codified legislation, the Anglo-American doctrine of rule of law may be found in the court's decision. Now, despite the polysemy of traditions which flow into the notion of the rule of law, I agree with the opinion whereby this tradition would be based on the same philosophical and political assumptions and stand for the same grounding values. Under this perspective, as Danilo Zola, an Italian philosopher, states, the rule of law is a normative and institutional structure of the European modern state within which the legal system is entrusted with the task of protecting individual rights by constraining the inclination of political power to expand, to act arbitrarily and to abuse its prerogatives. Now, more squarely, two principles underlie the rule of law so conceived: the differentiation of power and the diffusion of power. In particular, the principle of differentiation plays a dual role, being aimed at separating both the legal political system from our social subsystem, like the economic or religious one, and the state function consisting in enacting legislation from that of enforcing legislation. The principle of diffusion of power sets, on the other hand, to limit state powers by means of explicit restraints and to expand consistently the scope of individual freedoms, making them more and more independent from political interference. Now, the last mentioned principle, the principle of diffusion of power, entails in turn a number of further principles which include, among other things, due process of law, reasonable expectations, and proportionality. Now, the question is whether such guarantees may be regarded as general principles of the European Union. No doubt, especially where these principles are understood in terms of principles common to domestic systems, a task like this is very demanding. But in order to answer the question, let's take into account the EU practice. Well, in a celebrated judgment known as Lever, the European Court of Justice referred to the European community as a community based on the rule of law, inasmuch as neither its member states nor its institutions can avoid a review of the question whether the measures adopted by them are in conformity with the basic constitutional charter, the treaty. In other words, while the Court's judgment, which has been passed on 1986, does not explain the origin and meaning of the rule of law at community level, it is clear that the Court implicitly views the rule of law both as a positive good in itself and as one of the fundamental principles underlying the entire constitutional framework of the European community. From that moment on, of course, much water has flowed under the bridge, and several references to the rule of law may be found within the EU's realm. This is recalled by Article 2 of the Treaty on European Union, as well as by the preambles to the Treaty and to the Charter of Fundamental Rights. This is also why, under Article 49 of the Treaty on European Union, respect for the rule of law is a precondition for EU membership. Unfortunately, and this is the problem, this widespread support for the rule of law has not helped clarify the normative basis and content of these principles, of this principle within the EU, going so far as to have inspired a large number of interpretations by legal writers. To date, doctrinal discussion rests on two main alternatives, whose terms may be summarized as follows. Verhoeven, who is a distinguished international lawyer, moves on from the wording of Article 6, Paragraph 3 of the Treaty on European Union, whereby fundamental rights as guaranteed by the European Convention for the Protection of Human Rights and Fundamental Freedoms, and as they result from the constitutional traditions common to the Member States, shall constitute general principles of the Union's law. Well, moving on from this assumption, Verhoeven argues that the Union cannot define the rule of law in an autonomous manner and would be obliged to respect it as it is common principle of Member States. In other words, according to Verhoeven, national constitutional traditions offer both the reason why fundamental principles are to be respected by the Union and a basis for determining what these principles mean in the Union context. Curiously enough, the same Verhoeven adds that these principles are open-ended categories, and that there is a marked difference in how these principles are understood in the various member states. The concept of relativity relied on by Paresh this morning. The same ambiguity may be found also in the 2014 communication of the European Commission quoted by Marine. Now, in a nutshell, and that's the paradox, following a reasoning of this kind, so following the interpretation of Verhoeven, one should argue that the Union would be under a legal obligation to define the rule of law on the basis of a common denominator that actually does not appear to exist. On this assumption, other authors like Kochenov advocate a strict separation between national definitions of the rule of law and the EU definition of the rule of law. In other words, according to Kochenov, it is impossible to draw direct parallels between the national legal orders with respect to the precise meaning of the rule of law exposed by each system. This opinion, so the opinion maintained by Kochenov, is the most convincing one, but the problem is that it does not provide any solution to the question here scrutinized, neither in terms of the normative basis of the EU rule of law, nor of its content. Going more into detail, there is no doubt that the principles which the EU rule of law seems to be based on do not embody, in my personal opinion, principles common to domestic systems. Let's take into account, for example, the principle of legitimate expectations, which is a traditional manifestation of the rule of law. As is well known, the rationale behind the principle of legitimate expectations rests on the need to protect the individual's reliance on the conduct of another private party or of the state. So the principle is relevant from both a private and public law perspective. From a public law perspective, more in particular, what the principle calls for is a fair balance between individual interest in maintaining a given legal situation which has been relied on for the purpose of its assessments and decisions, and on the other hand, the state's power to change this situation. That is to say, to exercise its normal regulatory function in the public interest. Notably, this very principle, so the principle of reasonable expectation, plays a crucial role also in the field of European Union law, but its legal nature continues to be shrouded in ambiguity. Several authors regard legitimate expectation as part of the body of general principles common to domestic systems, yet their I would say lines of argument are not altogether convincing. In detail, while the principle is provided for by the overwhelming majority of EU countries, its scope as well as the conditions under which it may be guaranteed differ greatly according to each country and of course its peculiar legal tradition. In Germany, for example, the principle which is known as Vertrauensschutz, literally protection of trust, is enshrined at the constitutional level and applies not only to decisions and representations made by public authorities, but to legislative measures as well. On the contrary, in other countries, the scope of the principles tends to be narrower, inasmuch as expectations mainly give rise to procedural rights. Individuals are entitled to participate in the decision-making process of public bodies, but they are not safeguarded from changes of legislation, for example. Lastly, some countries do not provide any express protection for legitimate expectations, which is probably due to the presence of other principles having a similar function. Now, in this light, and so, if no common denominator can be found, all that can be said is that the EU is entitled to redefine, in my opinion, the meaning and scope of the rule of law to fit the distinct features of its autonomous legal order, and this is exactly what has been done and continues to be done. Turning again, for example, to the principle of legitimate expectations, the EU has elaborated a notion of expectations by legislation which is specific to the European Union only. This is the model of expectation by induction which the European Union Court of Justice follows when establishing whether a private party can rely on legitimate expectations against the exercise of normative powers by the EU's institution. According to this model, the individual's expectations must be protected where the law that is going to be modified embodies a previous qualified conduct of the legislator, that's a normative act providing for the future with a specific aim to induce a certain decision and which the individual relied on in assuming that decision. That's just an example. This circumstance, in my personal opinion, may be easily explained if one recognizes the existence of a twofold category of principle within the EU context, which replaces a distinction which works at international level as well. I'm talking about the distinction between principles common to domestic systems and general principle of EU law with their own foundations in the EU legal order itself. Of course, in my opinion, the EU rule of law is part of the second category of principle, which may be described as follows. General principles of EU law are identified on the basis of the normative dynamics peculiar to the EU legal order itself, which means that they are inferred by way of induction and generalization from the EU treaties provision. So, for instance, it is clear that whenever an EU provision speaks of legal certainty, for example, the principle of legitimate expectation is implicitly presupposed. On the other hand, once the principle is identified, from this principle is extracted the rule to be applied in the case in question, like, for example, the rule of expectation by induction. Of course, who is in charge of this interpretative task is above all the EU Court of Justice, which, as always, ends up being the most important motor of EU integration. Thank you very much.
Thank you, Professor Palombino, for a very interesting speech. And now we will be hearing Simas Grigonis, who will be talking about conflicting constitutional values, autonomy of EU legal order versus human rights.
Here we go. So, hello, dear colleagues. I would first of all like to... Okay, thank you. I would first of all like to say that I'm really happy being here and I'm really enjoying all the insights that you're providing today. It's really interesting to participate. And today I'm going to talk about the conflicting constitutional values, to be more precise, the autonomy of the European Union legal order and human rights protection in the European Union. The topic was several times already mentioned today with regard to the opinion 2/13 of the European Court of Justice, and my presentation will be mainly related to this opinion, and several important aspects are going to be analyzed in the presentation. So, yes. Yes, a little bit about the context. Human rights protection, as we know, in the European Union evolved gradually. European Union itself was created as a reaction to the World War II. And I believe the problem today is that people have already lost this perception why the European Union was created. Yes, it was first of all created as an economic organization, but this was not the primary objective of its creation. The primary objective was to protect other values that were hindered and destroyed during the World War II. It was peace, security, and human rights, first of all. And it is economic integration that was used as a tool in order to protect all these other more important values. Today, this perspective is lost, and as I see it, the situation in the European Union, we are a little bit lost in the details, a little bit lost in the procedures, and we don't see the purpose anymore why we're doing this, and what is the more general idea and the value of why we are creating European Union and why we did it 60 years ago. For me, as a child of independent Lithuania, it's really easy to know what the perspective, like this loss of perspective means, because I haven't seen the Soviet era. I was born in the free Lithuania, so I can, even when people are talking about Soviet regime, it is already only a tale for me, because I haven't experienced it myself. For me, the history that I can contemplate on and that I perceive myself from my own experiences starts with 9/11 and 2004 when Lithuania became a member of the European Union. That's like the most significant events from my own experience. So it is not really surprising that people do not really understand what happened in 20th century when the World War II happened and when the European Union was created. So yes, it was an economic integration, first of all, but in order to protect the greater values. And later on, Court of Justice developed human rights as a general principle in Stauder case. Then Charter on Fundamental Rights was introduced in the European Union, and the European Union's accession to the European Convention of Human Rights was supposed to be the apex of the process of protecting human rights in the European Union. However, Opinion 2/13 happened, and the accession was blocked by the Court of Justice because of the motives of protection of the autonomy of the European Union legal order. When we are speaking about autonomy, it is not really a very popular principle that is usually discussed among legal scientists. It was developed in other opinions of the Court of Justice. First of all, in the opinion regarding European Economic Area Agreement. Second of all, the European Patent Court. And the general idea of principle of autonomy is protecting the coherency of the European Union legal order, which means that basically there are two elements. First of all, Court of Justice protects its own right to interpret European Union legal order and the European Union laws. And second of all, through protecting its exclusive right to interpret European Union law, Court of Justice protects uniform interpretation within the European Union legal order. This is like general definition of autonomy, which is provided by the court itself, and what the opinion 2/13 had to answer is whether the accession agreement of the European Union to the Convention of the European Convention of Human Rights was compatible with the treaties. As we know, the court told that it was not compatible with the treaties because it adversely affected the autonomy of the European Union legal order and the specific characteristics of the European Union law. And there are several implications that follows from this decision provided by the Court of Justice. First of all, European Union will not accede to the European Convention of Human Rights in the nearest future because the negotiation procedures, like for the first agreement, this agreement took many years, almost a decade, and it would have to be done again with regard to another agreement. And the second thing, European Court of Justice once again rejected jurisdiction of external judicial body to perform judicial control over the European Union laws, and rejected the possibility for outside judicial body to check whether European Union was not infringing international law by itself. There are two aspects that I would like to talk about today. Two arguments provided by Court of Justice with regard to the protection of autonomy of the European Union legal order. And the first one presented by the Court was that Article 53 of the European Convention of Human Rights was not compatible with Article 53 of the Charter of the European Union. Article 53, to say it in really simple words, Article 53 of the European Convention of Human Rights provides for the possibility for the member states to the convention to stipulate higher human standards than the ones that are indicated in the convention. However, when we are talking about the Charter, the Court formulated its position that the human rights standards indicated in the Charter are the highest possible standards in the European Union legal system. So therefore, if the Convention allows for the member states to stipulate higher human standards, then it would not be compatible with the European Union law requirements, because European Union law requirements requests for the member states to prescribe only such level of human rights protection that is indicated in the Charter. The reasoning behind this is the uniform interpretation of the human rights indicated in the Charter of Human Rights. So if the member states were allowed to put bigger standards into their legal orders, the uniform interpretation could be affected, and that would negatively affect coherency of the legal order. So this is the first argument presented by the court, and as we can see, it is really controversial because on the one hand, we declare that we protect human rights in the European Union. On the other hand, the court itself is saying that higher human rights standards are not allowed, even if member states wanted to do it and to present it into their legal systems. So we have a paradox here, which I believe is not really logical if we really protect human rights in the European Union. The second argument presented by the court was that the principle of mutual trust between the member states would be affected. So this principle concerns area of freedom, security and justice. The If we speak in simple words, member states have to trust each other and each other's laws, which applies in their domestic systems. That concerns security of freedom, security and justice. Because if member states were allowed to question each other's legal systems, once again, it would hinder the underlying balance of the European Union legal order and coherency of the legal order. So member states must trust each other's national laws. And what the Convention would have brought within the legal system of the European Union is the possibility for the member states to question each other's human rights standards by referring to European Court of Human Rights and instituting proceedings with this regard. So, according to Court of Justice of the European Union, such possibility is not allowed under European Union law because, once again, member states must trust each other with regard to human rights standards and should not question each other's human rights protection level. According to court, it would be okay if member states were allowed to question, like, third countries' human rights standards that are not the member states of the European Union, but it's not okay if they do it among each others. This is once again a paradoxical evaluation of the situation, because if we really protect human rights, why shouldn't we be allowed to assess other member states' laws in, like, whether they conform the requirements of human rights? And yes, so the conclusions that we can come up from these insights is that the autonomy of the European Union legal order is the prevailing value in this context, and it is implemented in such a way that hinders human rights protection in the European Union. And we can certainly ask in this context whether the European Union really intends to go forward with further human rights protection by acceding to the European Convention of Human Rights. And again, if we implement these requirements that the Court of Justice requests by its opinion 213, we should once again consider if it's worth doing, because if we implement what the court is requesting, then the whole idea of human rights protection will be lost, probably, because member states would not be allowed to institute higher level of human rights protection, and would not be allowed to question the level of protection in other member states. So these are the problematic questions that I would like to finish, and maybe during the discussion we can try answering some of them. So thank you for your attention.
And now Petr Navratil from Charles University in Prague, Czech Republic, will be talking about non-contractual liability of the EU as a fundamental right guaranteed by the Charter of the Fundamental Rights of the EU.
Good afternoon, ladies and gentlemen. I have to admit that I haven't realized that there will be a native French speaker in this room, and I'm about to pronounce a couple of French words I would like to hereby apologize for my terrible French pronunciation. Anyway, the topic of my presentation is whether the right to have the EU make good any damage is a fundamental right, and if so, whether it has any implications whatsoever. I'm quite sure that you will all agree with me that the Treaty of Paris is, with no doubt, quite fascinating for many reasons. And one of these reasons lies in the regime of non-contractual liability, which was, from the very beginning of the European integration, an integral part of EU legal framework. This is quite thrilling, especially considering the fact that it took many decades until non-contractual liability of international organizations was recognized. Of course, it could be claimed that the founding fathers considered judicial protection of individuals so important that they decided to include non-contractual liability into the Treaty of Paris. However, as Maurice Lagrange, who was actually the first Advocate General and a man who participated in drafting the Treaty of Paris, contended in his memoirs, the prosaic reason for including a regime of non-contractual liability in the Treaty of Paris lied rather in interest of big international companies conducting business in the field of steel industry than noble ideas of founding fathers. One way or the other, the fact is that the regime of non-contractual liability was included in the Treaty of Paris, and it was heavily inspired by French concept of faute. In other words, from the very beginning of the European integration, individuals seeking compensation for loss or injury had to prove that there was sufficiently serious breach of law on the part of acting institution, apart from damage, and link between the damage suffered and action of the institution in cause. Later on, being under influence of German Schutznorm theory, the condition has altered so that a sufficiently serious breach was to concern a breach of superior rule of law for the protection of the individual. In that regard, it should be noted that the approach of the Court of Justice was from the very beginning case-based and rather restrictive. Provision stipulating non-contractual liability was revised by the Treaty of Rome, and since then it has been more or less the same. Nowadays, non-contractual liability of the European Union is stipulated in Article 340, Treaty on the Functioning of the EU. However, this legal regulation is rather minimalistic, as there are no conditions mentioned apart from the general principles common to the laws of the member states. However, as the Charter of Fundamental Rights of the European Union became legally binding thanks to the Treaty of Lisbon, some commentators claim that the Article 41 of the Charter, which stipulates that every person has the right to have the EU make good any damage caused by its institutions or servants in the performance of their duties, that this right to have the EU make good any damage turned from a simple right to a fundamental right. For example, current President of the Court of Justice, Cohen Leonard, in his book EU Procedure Law, which is, by the way, a Bible of EU procedure law, writes about this change. However, interesting thing is that commentators fail to explain what does this practically means, if anything. In that regard, it should be emphasized that even before adoption of the Charter of the Fundamental Rights were protected under EU law as a part of general principles. According to case law of the Court of Justice, a famous Schmidberger case can be noted. For example, one of the sources of general principles in the sense of fundamental rights were, and still are, common constitutional traditions. Now, right to have public authorities make good any damage caused is, for example, included in Article 36 of the Czech Constitution, or Article 34 of German Grundgesetz, or Article 121 of Spanish Constitution. Furthermore, even Article 15 of Declaration of the Rights of Man and of the Citizens, adopted in 1789, provides a regime of non-contractual liability of public authorities. Therefore, there are no doubts that a right to have the EU make good any damage was fundamental right recognized within EU law even before the adoption of the Charter. Therefore, there is no change which could be connected to regime of non-contractual liability of the EU, at least as far as the formal point of view is concerned. Now, it would be possible to accept this simple or trivial conclusion and end our case. However, inclusion of non-contractual liability of the EU in the Charter reflects the central role played by action for damages as part of ensuring the right to good administration on the part of the Union. Therefore, one has to ask themselves whether this simple declaration has any effect whatsoever on the case law of the Court of Justice, or better, on the conditions which are to be met should an individual successfully seek compensation for loss or injury. As I've already mentioned, there are basically 4 conditions regarding non-contractual liability of the EU. First of all, there has to be loss or actual damage. Secondly, there has to be unlawful union act or conduct. Thirdly, of course, there has to be a causal link between the damage claimed and unlawful union act or conduct. And finally, there has to be sufficiently serious breach of law. Regarding the condition of sufficiently serious breach of law, from 1970s, the Court of Justice made a distinction between legislative measures which involve choices of economic policy and other administrative measures. However, this distinction was quite unclear, and therefore individuals claiming damages were facing high level of uncertainty. Therefore, in the 90s, the Court of Justice decided to follow a different path. Inspired by case law concerning non-contractual liability of member states, the Court of Justice adjudicated that the sufficiently seriousness of breach depends on the limits on the discretion. Should the limits on the discretion be manifestly and gravely disregarded, then the EU is to pay for damages. It should be emphasized that the Court of Justice considered limits on the discretion even in its previous case law. Nevertheless, the regime of non-contractual liability of the EU was reformed only when the Bergaderm decision was rendered. Moreover, quite interesting is that in Frankovic case, the Court of Justice argued that since the EU is liable for damages, the member states should be liable for damages as well. In other words, the regime of non-contractual liability of member states, including conditions to be met, was derived from the regime of non-contractual liability of the EU in Frankovic case and subsequent case law. In Bergaderm case, the Court of Justice claimed it would be not appropriate if the conditions of non-contractual liability of member states were different from conditions of non-contractual liability of the EU. Therefore, effectively adjusting conditions of non-contractual liability of the EU to conditions of non-contractual liability of member states, which happened to change since Frankovic case. This is, by the way, a lovely example of circular reasoning, my favorite one, actually. Anyway, the fact is the finding of sufficiently serious breach of law has been dependent on limits on the discretion of acting EU institution or servant. However, shortly after Bergaderm case, it proved in practice that it has been still very difficult to assess the fulfillment of this condition of sufficiently serious breach of law, as we can see, for example, in famous Holcim cases. Of course, the Court of Justice has continued with developing its doctrine regarding non-contractual liability even after the Charter had become legally binding. There are two quite interesting cases. One case of José María Sison was delivered in 2011, and the other one, the case of Arte Gudan, was delivered in 2012. Both cases react on Bergaderm case. To make it shorter, the question was whether, if there is no discretion whatsoever, can we come to a conclusion the non-contractual liability of the EU does occur quasi-automatic, of course supposing the other conditions have been met. In that regard, the Court of Justice ruled, no, not a chance. For it is actually necessary to examine the circumstances of a particular case, such as difficulties with interpretation and application, complexity of facts, existence of intention, and so on. In other words, it is necessary to examine whether an administrative authority exercising ordinary care and diligence would cause damage if it was the acting institution or servant. Therefore, it can be concluded that after the Charter had become legally binding, the regime of non-contractual liability became even more restrictive and individuals unfriendly. Ladies and gentlemen, cui bono? This famous sentence written by Cicero expresses the idea that there is always a motivation behind a human conduct. In that regard, it is my honest opinion that the Court of Justice adopted such a restrictive regime of non-contractual liability of the EU in order to make sure that the action readiness of EU institutions and servants would not be jeopardized. It is beyond doubt that public authorities could and should be protected in case their actions are connected with legitimate choices of various policies. However, even though the Court of Justice many times declared that action for damages forms an important part of effective judicial protection of individuals granted by EU law, from the case law of the Court of Justice, it is apparent that the Court of Justice is rather guided by efforts to secure wide scope of discretion for EU authorities than by effort to ensure individuals are well protected. Therefore, taking into account especially the purpose of claim for damages, its place within the system of judicial protection granted by EU law, an approach of the Court of Justice to action for annulment, in that regard I believe the famous Plowman case should be noted. I would like to mention, it can be concluded that the approach of the Court of Justice is way too restrictive and untenable. Some commentators, like Kathleen Gutman or Cohen Leonards, speak about the so-called balancing factors, which were accepted in favor of the EU. As I have already said, the Court of Justice was right to develop such balancing factors. However, the Court of Justice should not forget about individuals and should develop some balancing factors in their favor as well. In that regard, there are some convenient solutions to be found in the national law, such as French conception of responsabilité sans faute, la responsabilité pour risque, or la responsabilité pour rupture de l'égalité devant les charges publiques, or German conception of victim. Nevertheless, the Court of Justice decided not to acknowledge non-contractual liability in the absence of unlawful action or conduct in famous Fiam case. Of course, the factual background involving a big international company and WTO legal framework was not the best for bringing a change in approach to non-contractual liability of the EU. However, it is my hope that in the light of the Charter and the right to good administration, the Court of Justice will eventually reconsider its approach. Ladies and gentlemen, thank you for your attention.
Well, this was the last presentation during this plenary session. I would like to thank all the speakers for the presentation. All the speeches were very interesting, and they were dealing with extremely important law institution and legal practice. So I open the discussion.
I just have well, first of all, thank you very much for your wonderful presentations. Such diversity, such richness, I'm very fascinated by everything that you all said. I must ask a generic question, and it sort of relates back to a theme that I've been pursuing throughout today. This separation, well, first of all, this notion that a value has a normative aspect, a strong ethical aspect, where a guiding principle as such. And I wonder as to what extent a value can be consistent with politics. I see a value and a notion of a political objective or ideal as being separate. I think a value is distinguished by a strong moral or normative concept. The idea that something is right to pursue for itself because it's a good in itself. Whereas I think a political objective isn't something that's good in itself, it's instrumentally good for a given organization or a given body at any particular time. So I see there being a distinction between a value, which I think is wholly good in itself, and a political objective, which is good for a particular body at any given time. If we carry that forward, I wonder to what extent we can call the values or the objectives enshrined within Article 2 of the Lisbon Treaty values. Can the rule of law be a value at the European level? Can solidarity be a value at the European level? I think that the rule of law can be a value in the legal context, in a domestic context. The reason for that is a separation of powers. In a national context, there's often a strong separation of powers between the legislature, the executive, and the judiciary. And what happens is that we can entrust an independent judiciary to ensure that the executive doesn't abuse the law and can ensure that the notion of the law being a good in itself is upheld. So therefore I can see how the rule of law can be a value within a domestic system because of separation of powers. And it stops it from being abused by the law being abused by those who are involved in political processes. But the EU is a political institution, it's a political creature in and of itself. So therefore, when it's seeking to enforce the rule of law, it's not enforcing it as a value in itself, it's enforcing it as a political tool. And even when the European Court of Justice is enforcing the rule of law, it's doing in a way in order to placate or reconcile the interests of many different states as a political objective. So my argument, my point would be whether we can't call these values because the distinction between politics and the good is not being maintained. I think that in the European context, things like rule of law, human rights, dignity, solidarity, these become highly politicized. And so they're political objectives for a given good for somebody as to being a value and being a good in itself. So I don't think they are values, I think they are more political ideals.
Okay. Okay, do you have a round of answers?
Thank you. So first of all, thank you to all the speakers in this afternoon session, because all the issues concerning fundamental rights were absolutely interesting and touch issues which are very important for the ordinary life of all of us, I think. But let me also thank Paresh, because I subscribe to every word he just said, because it gives me the I think I should shut up afterwards, because I really subscribe what he said. But just to add some practical examples to the question he raised. One concerning the rule of law initiative. Do you think, and of course my question is mainly to Marina and Fulvio, but to everybody in the room, do you think that one day the rule of law initiative will work? I mean, this, when the proposal of the Commission was tabled, I witnessed personally a kind of drama in Strasbourg, because the so-called sister organization of the EU, the Council of Europe, said, I mean, why do you need a mechanism on the rule of law when you work with an organization which has among its aims the observance of the respect of the rule of law, which has established organisms for this. One is the Venice Commission. So when this could be perceived, a kind of jealousy between organizations, but it's not, in my opinion, because all the 28 are also members of the Council of Europe. The European Commission can ask independently opinions to the Venice Commission, which are related to the rule of law. So why the need of a special, let's call it special procedure, borrowing the term from the UN vocabulary. So I do think that the political leverage of the rule of law will be evaluated only when the rule of law will be used. As a fact, the Commission answered that, being Article 7 a nuclear option, something was needed in between nothing and Article 7. So the first is a real question. Do you think that one day we will see, I do not discuss the seriousness of possible violations which are currently under observance, but I mean, why do not think a little bit wider and imagine these issues of values, not only within the organization, as you just said, but within a community of values which goes beyond the borders of the EU. The other question is on, of course, on the EU accession to the European Convention on Human Rights, and I refer to a recent speech of the jurisconsult of the Council of Europe. Once again, he delivered a speech on invitation before the Constitutional Affairs Committee of the European Parliament this April. More or less the content is the same of a speech he delivered in last year, but of course he says, I belong to the Council of Europe, I don't want to express an opinion of the organization on an opinion which is outside the organization, but he raised the issue on which you insisted very much, Simas, the one of mutual trust. But instead of discussing mutual trust between the EU and its member states, he said, once again, mutual trust between organizations. I mean, And once again, he repeated the solution to the legal arguments put forward by the Luxembourg court need to be found into a political backing of legal amendments. Just referring to the last intervention, the one on non-contractual liability, once again, I mean, if we discuss conflicts among principles, whether we believe or not, or we describe, or we name them among EU principles or general common principles, I mean, discussing the EU, we should put them into the reality of an organization, and which is not a state, nor a superstate. Thank you very much.
I think that was articulated wonderfully. Thank you very much for that. That was a great articulation of something which I was thinking. I just want to ask another question, if I may, or make a point, and I want to welcome, it kind of follows on from that. I think that when we talk about the rule of law in a domestic context, I think it's what I would call a declaratory rule of law. I think that within a country or within a state, there's an acceptance, whether it be a constitutional acceptance or whether it be a spiritual or moral acceptance, that the law is there for everybody is equal before the law, and that if somebody is treated unequally, whether that be because legitimate expectation hasn't been followed, they can go to the court and the court can declare that, sorry, that's against the rule of law. So what the court is doing is just declaring what the position already is, that the rule of law exists within our state and therefore it should be respected. Whereas I think that I would go as far as to say that in the European Union there is no rule of law. There is no expectation from the very beginning that there is a rule of law. It's because they know that they are coming in a state, they know they're coming from a common basis, a constitution, a history, a consensus. Whereas I don't think that actually exists in Europe, and they're coming at it from a fragmented position. They know that they have competing interests, although they might want to say that they have common interests, but they know they have competing national interests. And so what the institutions are doing is not declaring the rule of law, they are restoring the rule of law. They're seeking to enforce the rule of law, impose something upon it when it doesn't actually exist in the first place. So one is declaratory of something that already exists, one is imposing something that by its definition can never exist. Possibly.
Do you want me to start?
Yes, of course.
Good luck. Okay, perhaps I could start with your point. It's very similar, but I think that when Robert Schuman proposal to Adenauer to Germany was very original, a breach of normal way of solving problem in international law. And why that proposal was done, because there was a delusion in the Council of Europe, which was supposed to be the only European institution, and because of that delusion, in the choice of the structure, how the aim was very clear, and they were all agree on peace. But the problem was the methodology that differs, specifically with British in that time, just to change between French and British. And so the delusion was the choice of the Council of Europe to keep that traditional global approach, so political and global approach, and then we do something concrete in a second time. The inversion that was imagine, not only, of course, of Robert Schuman is the speaker, but of course he was not alone, but let's say Schumann's proposal was to invert and to start with concrete elaboration, construction, and because it's difficult to imagine now, but at that time it is exactly like Israelis and Palestinians. It was not easy, and if I think about my grandmother, for example, I could imagine that saying to my grandmother, you know what, we will do a big construction together with German, she had the German occupation at home really inside the home. It was not easy, and by the way, this is an answer to this morning, this morning question. I'm not sure that we should always ask the population what is the opinion, because in this case probably she would have said, with the German? No. Could we choose someone else? And no, we couldn't. That was the exact nation to build peace with. It's the same with the death penalty. In France in 1981, no one was really in favor of death penalty, of abolition of death penalty. And if you ask now to extreme right, Marine Le Pen is in favor of death penalty. So it's not always good to ask to the population. This is a paradox of democracy, by the way. It's not always good. So coming back to this, the inversion was it's easier to agree on a very concrete and economical aspect, like coal and steel. It was fundamental, of course, but it was very technical. It was not political. And if we think about our opinion about the entry of Turkey in the EU, it's very political, and we could fight in 5 minutes, even just here, because it's a delicate question. So it was easier to start with something very concrete. But this worked, but there is a cost to that choice. And the cost is democracy, human rights, values, rule of law, because it comes in a secondary time, and it's much more difficult. And that was the intuition they had. It was true. It's more difficult to agree on values. It's like sanctions. It's easier to say, okay, you made an agreement, advertisement agreement, and you will be sanctioned. And the financial sanctions are very high. So states are ready to pay. Not very keen on, but they're ready to pay. If now we have to say, you infringe the value and you're not a democratic country, then it's much more difficult to say to another state and to accept for another state, without mentioning anybody of here, to maintain peace between us. It's much more difficult. So I think we are paying the cost of the methodology, what was the success of the EU, if we compare to Council of Europe. Of course, the European Convention is fantastic, and the European Court is doing a very huge and wonderful work, perhaps too much success for the Court of Justice of Luxembourg to accept the idea of being under that case law. And so it's gradually that we come to these more difficult aspects, and it's perhaps not an easy moment to do it, because the rest of the world also is under trouble. For me, it's not that values and political are different or are opposed, is that political choices should follow values. Values should inspire the political choice. But again, it's more difficult to agree on a political direction than economical or concrete.
Do you think politics and values can be consistent? Are they one and the same?
I think politics should be the further step. I mean, the value should inspire you, and then you should you have the political, that is the concrétisation. Wow. I don't know how to say that in English. Making the forward. It's nothing against for me. It's just the next step. It should be inspired by values. So I don't think any difference. But I think it's the same difficulty internal if I think about France, we, as you know, we have difficult time for different reasons, and it's very much about fear. We are very much all, as individual, I mean, and French perhaps in particular, are very much lead by fear. And if we continue to let the fear lead, we could have a fear leader and go and really go in a dangerous road. My opinion about Brexit is a little bit like this. Now, it's fear, that is fear of migrants, fear of terrorists, fear of, and also fear of who will lead France, and fear. So, in a way, Europe is just similar to what we have internal in our own countries. And what I say to French most of the time is that they are similar to what we are. Look at your life. Do you think they are very well managed, your private life? So how could you consider that politicians are not dealing very well? When you look at yourself, it's the same, and Europe is the same as internal management. So we should look at inside ourselves before criticizing other levels. But I don't want to...
No, I agree with you in the sense that, so I spoke of the rule of law, not in terms of its violation, but in terms of its content. Okay. From this perspective, so the assumption from which I moved is that a principle is a principle, in the sense that a principle, by definition, indicates a direction to be followed, has a directive function. So from this point of view, I can agree with you, Paresh, that principles have a political function, okay? But I think that it is not possible to make a difference between the European Union level and the national law level, in the sense that a principle is a principle in Europe and is a principle in a national legal system. So the function of a principle, at least this is my opinion, is always the same. There is a difference, of course, between national legal systems and the European Union legal order from the standpoint of the content of these principles, which, I repeat this, by definition need to be concretized, as Marine said. And so from this point of view, it is quite clear that within a national legal system, it's easier to, for example, extract a rule from the rule of law principles. At the European Union level, of course, this is quite complicated. But the example which and also, for example, this, what you said about the separation of powers. Well, in a way, we have the principle of separation of powers also at the European Union level. But in any case, the example which I relied on, whether a private party can rely on legitimate expectations against the exercise of normative powers by the EU's institutions. This is a very practical question which needs, in a way, to be solved. And it is quite clear that if the European Court of Justice has to establish what is meant by expectation, by legislation, of course this is a very demanding task. And what happens a lot of time, I also think about the last presentation, is that the European Court of Justice decides to follow the approach followed in one state, so just in one single state, because sometimes it is really very, very difficult to concretize the rule of law, to say, for example, what is meant by expectation by legislation. So we know how this principle works in Italy, we know more or less how this principle works in Germany. I'm sure that a principle common to domestic system does not exist, and so it is true what you say, that there is, from this point of view, a big difference between national legal systems and European Union legal order, in the sense that the task of the European Union Court of Justice is a very demanding task, but in the end, so at the end of the day, a principle must in any case be concretized. Otherwise, a principle is not able to work. Thank you.
If I can ask you, so do you think that, it's a pretty broad question in light of what you said, but do you think that rule of law that there is currently a rule of law in Europe, that in the EU it does exist, and if so, what shape does it take? Because I don't think that there is a rule of law currently. I think it's in a perpetual state of flux. And the thing is, rule of law presupposes a degree of stability, that there is a certain stability that underpins whatever entity it is. And for me, I see the EU as being in a constant state of anarchy and flux, and is trying to reach a resolution which is the antithesis of what the rule of law actually is. So would you say that there is a rule of law in the European Union? And if so,
no, I think that there is a principle, a rule of law principle, which needs to be concretized. So it is impossible to say that we have currently a rule of law at the European Union level with a precise content. What I noticed that in some respects, the European Court of Justice was able to give a solution, but of course it is not possible to say that currently we have a rule of law principle at the European Union law level with a precise content. Yeah, of course.
Probably the solution would be more Europe than less Europe. We don't have the rule of law now complete, we all agree, but perhaps it's because of the international law. So the weight of the state, by the way, with the difference with the so-called important states and less important, which shouldn't be the case in the EU, is too much. So we have to abandon our completely, the sovereignty that we never accept to abandon. Clearly, this is the biggest breach in the international law that exists, and there's no other system like this in international law. It's the only one. So probably the solution would be something more radical, but people are not ready because they think that it would be better done at home, which is not sure, and depends also on who you rely on, which politicians you rely on.
Sorry, just to be more precise. So what I want to say is that we have a rule of law principle at the European Union law level, in the sense that we have the rule of law, which implies a series of principles, and some of these principles need to be concretized as yet. Because I spoke, for example, about the principle of legitimate expectation, which is a classical manifestation of the rule of law. But let's take into account, for example, the principle of proportionality. Well, if you take into account, for example, the Italian national administrative jurisprudence in matter of proportionality, and in particular those judgments which try to use the European Union law concept of proportionality, this is a disaster. So in the sense that we have a lot of different interpretations from this point of view. And of course, depending on how you apply such an important principle like proportionality, especially in administrative matters, of course the solution is different. Yeah, that's the problem. So.
The discussion shows that the presentation, all the presentation was very interesting. But if there is any other questions, I will close the session and start the coffee break, I suppose. Thank you very much.
že zatím nevím, co se od nás úplně očekává, ale snad tady to jí a nevím, kdo to má.
We are very pleased that he's not coming.
Wow.
Spíše to, jak říkáte, taková ta úleva,